he was not budging, the criminal slithered to the top and sought out the Palisa District CID, the boss, Detective Assistant Superintendent of Police, Fauzia Nachandiba. Seemingly, Detective Nachandiba accepted to connive with the criminal to make the case go away. Long story short, Detective Nachandiba found herself facing an investigation into her misconduct by the Police Professional Standards Unit after I lodged a complaint against her. I am empowered woman. The file case, PSU GEF 390 of 2021. PSU indeed found it was not proper for Detective Nachandiba to push me and the criminal to have the matter amicably settled. PSU recommended that Detective Nachandiba be cautioned to desist from settling criminal matters at police and should be directed to have the case file CRB 518 of 2021 forwarded to the Palisa resident state attorney. Ladies and gentlemen, we are talking about those who are incarcerated, but what is happening in the prison itself, in the police itself, when criminals are in collusion with police is heartbreaking. It is absolutely heartbreaking. You are forced, if you are a less empowered woman, if you are a poor person, you are forced to settle the matter. And who is forcing you to settle the matter? The police officers. Okay? Of course, I wasn't having any of that. Okay? I have my doubts that I am the only victim of Detective Nachandiba. There must be many. She was unprofessional in her conduct, and what is defined in the PSU report as desist from settling criminal matters at the police should have accurately been better stated as desist from accosting and harassing victims of crime. Because that is what happened to me. Detective Nachandiba summoned me to her office, and in the presence of 2 male police officers, including the investigating officer, she verbally accosted me and brought me to tears. Now, if she can bring me to tears, sincerely, what about those women in Nakapiripirit, in Odupakara? What about those women? If she can accost me and bring me to tears. And by the way, when she summoned me, I arrived in a powerful double cabin because I was on duty. But she brought me to tears. Okay? Woman-on-woman gender-based violence, as she frolicked for the affirmation and attention of the criminal. Okay. Anyway, imagine my shock when the Palisa resident state attorney of 2021 did not categorize my complaint as a criminal matter, and she declined to sanction my case file. Instead, she directed that I seek justice via a civil suit. How is it that PSU determined the matter's malicious damage of property, breaking and entering, theft as criminal in nature, and the Palisa RSA of 2021 determined different? I remain dumbfounded, but these are the realities. Rumors abound that when Detective Nachandiba presented the case file to Palisa RSA of 2021, significant evidence was left out from the file. But even then, would it not be the duty of the RSA to have queried the missing evidence? I am more inclined to believe seeming connivance with the criminal Detective Nachandiba, and the Palisa RSA of 2021 to make the case go away. We are talking about criminal justice. So criminal justice, I do believe, is wider than those incarcerated. Some of us are walking around the streets incarcerated with pain. I did register a complaint with the Office of DPP, Regional Office in Mbale, of my dissatisfaction with the Palisa RSA. After several follow-ups, lodging a complaint with ODPP Kampala, to date, nearly 4 years later, I have no formal response from the ODPP with regards to how it handled my complaint. However, last month, ODPP Kampala informed me that a 3 months plus investigation into my complaint conducted at the level of Kampala was completed. I was advised to follow up with ODPP Mbale Regional Office, which also in turn advised me to follow up with the Palisa RSA, current 2025, who in turn also advised me to follow up with Palisa Central Police Station, CPS. It has been over a month now, and I have made at least 5 inquiries with Palisa CPS. The registry and the district CID, I have no confirmation. The file is at CPS, and therefore when I will be given access and the feedback from ODPP. I would like for you to contextualize this reality with the kind of indigence for which you seek legal aid. However, for me as an empowered woman, concurrently in 2022, I retained legal counsel, Alan Ogoyi, and the team at the award-winning Okalang Law Chambers. On my behalf, they filed an ongoing civil suit, 18 of 2022, holding at High Court in Mbale. But let me tell you, when they filed that suit, they also filed for me to be awarded court-ordered protection. But to my shock and to our shock, my initial application for court-ordered protection was not granted. The Land Deputy Registrar at High Court in Mbale at the time, His Worship Eremye Mawanda, gave us a jaw-dropper when he declined my application for temporary injunction and went ahead also at the same time as denying the temporary injunction. He went ahead also and dismissed my civil suit without hearing it. Of course, we appealed. My legal team put up a good battle, powerful battle, and on appeal, the appellant judge, in describing the actions of His Worship Iremye, these are some of the words that the court used to describe the decision of His Worship. Now, look at me. I'm an ordinary Ugandan client of the bar, but these words I'm going to read out to you were the ones used by his colleagues to describe his actions. Appalling to say the least. Irregular, improper. Those are the words of the appellant court. Okay? Of course, immediately the case was reinstated and it is still ongoing in Mbale, and I was awarded a court injunction. But because of the fake bravado or the fake legitimacy that the initial ruling of His Worship Eremye gave to the criminal blatantly disobeys court orders. He continues in contempt of court. And so when I went to the police, I say, look, we have a court order here. Please enforce the court order. The police looked at me and they thought, okay, this trouble causer, we are not going to help her. The regional police commander himself escorted this man, the criminal, to my property and made it look like he had legitimacy there. The district police commander did the same. And so I filed again another case with PSU. The investigation was conducted, but 1 year later, I still do not have the report of PSU, because every time I go to the Directorate of Human Rights and Legal at the IGP's office, I am not given the report. Ladies and gentlemen, if they could do that to me, please, me, with the backing of you, the bar, on a retainer, what are they doing to those without legal aid? That was the purpose of my story, to present to you that if they can do that to me, what are they doing now to those? And with that, I contextualize now my story. This is how I tie my story to the proposition for redefining the criminal justice system. As highlighted by the Uganda Law Society, among challenges facing Uganda's criminal justice system is a 358% prison congestion. The total capacity for our country's prisons is only 22,203. 2003 prison inmates, okay? But as you heard, right now, there can be as many as 79,500 inmates in prison. What's more, 55% of those inmates are on remand. They are simply on remand. And in some cases, while incarcerated, they are waiting as long as 11 years. 11 years, I was told, to have their day in court for even a bail hearing. A gross injustice, Uganda Law Society has found. I dare surmise that a major contributor to prison congestion and long incarceration in remand has everything to do with how the police handled the relevant case files. Remember my story. The Police Crime Report 2024 is disturbingly revealing. A whopping 41.5%, nearly half of cases reported to the police in 2024 remain still under inquiry at the end of the year. Still under inquiry at the end of the year, 41.5%. This is the police crime report for 2024. Okay, only 37.4%. Only 37.4% of cases reported to the police were fully investigated, sanctioned by the ODPP, and taken to court within the year. Only 37.4%. Of which, when they got to court, those few got to court. By the end of the year, the majority, 53.3%, were pending determination by court. Talk about case backlog. If every year the police is functioning in this way, 33% only really underperforming ODPP and the police, and then when the cases get to court, 53% carry over. Then the following year, 53% carry over. These are the root causes of congestion in prisons. It would be interesting for me as a person, but I think as many criminal justice seekers, it would be interesting to learn the findings of the Uganda Law Society of the content of the police case files of the indigents in prison current. what is in those case files? What do they say? Do those case files even exist? People are in police, but we are assuming that the process was proper. Let us use the example. The Supreme Court recently ordered that those who are facing trial under the military code, their cases should be reviewed and transferred to civil courts or possibly even dismissed. I put it to you, ladies and gentlemen, have you seen those case files when those people were arrested? I see some people are shaking their heads, so I'm good there. So the whole point of my keynote address is that if it is the case file which determines justice, we need to pay attention to that case file, how the evidence is gathered, how the case file is handled through the different stages. It is extremely important. I mean, some of us, lay people, we are following Uganda Law Society and the members of the bar. Recently, in court, there was a situation of a missing case file, wasn't it? And we were told that the case cannot proceed without the... Please. I am perturbed. Seriously, I am perturbed by how difficult it is for justice seekers such as I to have full access to our respective case files. We must be able to have full access to our respective case files because that would be the only way to guarantee justice. When I report a crime, I should surely be able to have full access to know what the criminal has responded, and the criminal also should have full access to know what they are being accused of, so that each one of us, with full disclosure, can mount our defense or can mount our prosecution. We really need to think about the case files. What is happening in the area of the case files? When someone is getting arrested and they are being thrown in, do they have presence of legal counsel to ensure that the charge sheet is actually there, what they are being charged of, and what is their evidence of the charge sheet? I am almost ending. The lack of case files and the poor quality of police case files is a direct indicator of the unholy alliance I talked about between the police and ODPP. It is no longer sufficient for us to only focus on corruption, which involves money has exchanged hands. We should look at corruption which is weighted on the decisions of the judicial officer or the decisions of the actors within the legal fraternity. Individual actors within the legal fraternity, within the justice, law, and order sector, need to be held accountable for the decisions that they make. That means evaluating the decisions made and then going backwards to infer corruption. Even if money has not changed hands, we can infer that how did you arrive at this decision of dismissing a case that you have not heard? We can do that. ODPP not doing its job is the recipe that nurtures and contributes to case backlog and delays. I've already quoted the statistics for you. But most importantly, for me personally, case file CRB 518 of 2021, I have been denied justice. That I am pursuing a civil suit doesn't mean that at this level I wasn't denied justice. I was denied justice, and justice delayed is also justice denied. I need to know why my case file was treated as such. That is justice. Okay? Presence of judicial officers with questionable integrity and with legal incompetence within the judiciary, really? If we are talking about redefining the criminal justice system, surely the norm when an appellant court rules that the decision of a land deputy registrar was appalling, to say the least, should trigger a review of sorts. It should sound alarm bells about the possible lack thereof of integrity or likely incompetence of the judicial officer, or both. And that is why I join those who are demanding more transparent processes of how judicial officers get appointed. I'm concluding now. An important intervention that is needed to redefine criminal justice is to go back on track, re-establish and jealously guard a system of meritocracy within the justice, law, and order sector. I, for one, would cheer loudly when the kind of judicial service commission is in place that will hold judicial officers to account for the court rulings and the decisions that they make. And that judicial officers that make appalling rulings, to say the least, should not easily climb up the ranks. His Worship Eremie is now the public relations officer of the judiciary. For me, as one who has felt denied justice by him, that is how I see the judiciary, through their public relations officer. This is not a witch hunt, it is stating facts. The appellant court found that his decision was appalling, to say the least. The police are the front line who have the power to make and or break a case. It would appear that the unit that is intended to police the police, PSU, is not as independent and empowered as it should be. A more independent PSU that transparently investigates and publishes reports on complaints from people about the police can surely make police officers think twice before they choose to connive with criminals, such as the criminal I described for you. So my vision for redefining the criminal justice system is also to shine a torch and have a professional standards unit that is independent and allowed to transparently investigate the police officers that we have complained about, but also publish those reports. Their reports should not be subjected to going via the same police officers that they investigate. That unit needs to be isolated and made independent. President Museveni, I'm concluding, famously decried infected police force by Kawukumi weevils. We all know that situation. We can extrapolate that the presence of weevils is not only within the police force, but can also be prevailing throughout the different justice, law, and order sector. Now, when a bag of beans has weevils, there is only one effective way to get the weevils out. Put the beans out, let the sunshine come on them, and the weevils will exit. It is called solarization. In broad daylight, we need to increase solarization of individuals within the justice, law, and order sector, whether it be the bar, whether it be the bench, whether it be the police force, whether it be ODPP's office. We need to solarize Yanika or Loic. Bring it out and let us see it in broad daylight, and let us have a culture where people who misuse their positions in the criminal justice system are shunned. We cannot, as we have heard, we cannot sustain the situation where we are looking for funding year in, year out to deal with the symptoms of the problem. We must go and look at what is the root cause of the problem. The president of the Uganda Law Society, Isaac Semakade, I'm hoping he's online. The vice president of the Uganda Law Society, the entire Uganda Law Society Council, members of the bar listening in, hearing, thank you very much for granting me this platform to rant and also get mental health. Eyala Manoi.
Solo. Let's give a hand clap again to Nora. Very educative, very informative. Thank you so much. We're heading into the next item on the agenda. We won't take much time. We are told, Nora, earlier that this is a free speech zone. You don't need to. You are free within the ULS house to express yourself. This is a free speech zone. Even the speakers, no one is going to ask you. We have no limits to our freedoms on speech here. Allow me to invite now the next item. The next item is, allow me to invite one of our own, Miss Namuli Lydia. Lydia, please join me here. Please, a hand clap for her. She's going to moderate. She's going to moderate the panel discussion. Lydia is the manager, legal aid department at LDC. You're most welcome, Lydia. Before I even take my seat, I wanted just to leave you with some few figures to ponder about as you ask your questions. And these figures here must keep on being highlighted. 79,000 inmates. Possibly weaker or less influential than our keynote speaker. 55% on remand of those of that 79,000. 55, half that number. People who did mathematics, what number is that? 79 cut in half is what? That is, who can help us with that quick mathematics? 79 divided by 2. I can see the VP looking away from me. But half that number is on remand, and they are waiting for trial. 11 years. All these figures here really need to shock. We need to get answers and a way forward from persons that are joining us here. So allow me hand over to my sister here. The floor is yours. Please take the day.
Thank you, MC. Greetings and good afternoon to the participants here present and online, and to our distinguished panelists who I will introduce soon. As introduced, my name is Lydia Namuli. I'm the manager of the Legal Aid Clinic at the Law Development Center. I am honored, extremely honored, to moderate such a highly powered panel that will form part of our discussion, redefining the criminal justice system. With us on this panel is Dr. Sylvia Namubiru Mukasa, the Executive Director of LastNet. Dr. Sylvia, kindly take your seat. She'll be voicing out the views of the legal aid service providers who closely work with the criminal justice system. With us still on this highly powered panel is the representative of the Commissioner General of Uganda Prisons, who is Miss Victoria Nahemia, the acting head of the legal department. You're welcome, Miss Victoria, you can take your seat. We are also honored to be joined by the representative of the chairperson of the Uganda Human Rights Commission, who is Miss Ruth Senkindu, who is the Director, Monitoring and Inspection from the Uganda Human Rights Commission. Last but not least is the representative of the principal judge in this forum today, who is Her Worship Prosi Katushabe, the Registrar High Court. Your Worship, please take your seat. We are expecting the representative of the DPP, and if they join us, we shall introduce them to join the panel. So, members here present and online, allow me to start this conversation with the Executive Director of the Legal Aid Service Providers Network, Dr. Sylvia. The microphone is in your hands. Maybe before I start, I wish to acknowledge the keynote address by Miss Nora Owaraga. Thank you very much. You woke me up. And I'm hoping as we have this conversation with the panelists that maybe since they come from a high place and also within the system, they'll be able to respond to some of the questions you raise. You came through with a theme, dismantle. In her redefining the justice system, she is telling us to dismantle, and we shall hear from this highly powered force of how the keynote address theme can be addressed, dismantle. I'll start off with Dr. Sylvia, and Dr. Sylvia, kindly legal aid coverage in Uganda is estimated at less than 20% in these areas of need, particularly the rural areas. What targeted strategies are legal aid service providers using to close the legal aid gap for criminal suspects, especially in pre-trial detention?
Well, thank you so much, moderator, and I wish also to congratulate the Uganda Law Society for working the 15 years of pro bono. I feel proud that when I began here as a senior project advocate, then served as a head legal aid and pro bono services, and then in ED of Uganda Law Society. So I'm so happy that in 2010, we embarked on operationalization of pro bono, and it began as a pilot. And I remember lawyers even threatening to sue us. And we had to come up with a manual, handbook. And I'm glad that that now became mainstreamed, and we are now all speaking the same language. Back to the question that you have asked me, and in the interest of time, we all know that the criminal justice system is intended to prevent and also to punish behaviors and to rehabilitate in order to promote rule of law and public order. And to do this, we have systems in place, especially to operationalize Article 28 of the Constitution of the Republic of Uganda that provides for a presumption of innocence, but also ensures a fair and speedy hearing. We've heard Madame Nora, and you said we should correct some of the issues that have been raised. Madame Nora has been using the word criminal. We call them suspects because of the presumption of innocence. And so, why do we have the legal aid in Uganda? It's partly to promote access to justice for the most poor, vulnerable, and marginalized. The research is 80% of Ugandans, and we have a total population of about 45 million. 80%, according to Hill, cannot afford services of private practitioner. So 80%, only 20% are clients of private practitioners. Now, when we talk about 80, 1,076, according to the Uganda Human Rights Report, of now prisoners under incarceration, exceeding the capacity. It means 80% of those prisoners, who are actually mainly youth, cannot afford services of legal representation. That means their right to fair and speedy trial is violated, and therefore we have to come up and put up measures to ensure that we help them at the earliest opportunity. If we are to do that at the earliest opportunity, that would be good, because the Lilongwe Declaration says we don't wait for them when they're in prisons, but even before they make their statement, there should be a lawyer to hold them by the hand and advise them and give them advice concerning how to make this statement. So what have we done as Legal Aid Service Providers Network? Of course, we are about 60 organizations in Uganda, including the Legal Aid Project of the Uganda Law Society, that have set up legal aid models to where we employ staff advocates, paralegals, and we even engage with the communities to have volunteers who we have known as community paralegals, to be able to hold these people who cannot afford to get legal representation. Most of the legal aid service providers, especially those we call the primary legal aid service providers, have been approved by the Uganda Law Council, but others are creating awareness, and we are talking about prevention, while others are holding them and going to court and representing them. That is one of the model. The other model, we've had projects like the pre-trial detention of ASF and LastNet, where again we bring lawyers on board who go into police, who speak to the justice and actors to be able to improve on the bottlenecks within the justice system, especially observing the pre-trial rights of the suspects. We've also had the legal rapid response, which the Vice President has mentioned. The legal rapid response, especially during periods when there is a lot of arrests, people have demonstrated, talk about Article 102B of the Constitution, Article 126 when they were amending the land something acquisition, talk about during elections. So we normally mobilize lawyers, even including those of Uganda Law Society, to be part of those that are providing legal aid. We've had paralegals within the community, but some of the programs have ended, like the paralegal advisory services that was spearheaded by the Uganda Human Rights Commission. This would be now the chain between the justice actors to be able to bring to the attention, say, of the judicial officers, cases that have been clocked mandatory bail, cases that need bail, among others, and cases that need to be fast-tracked for trial. We've had awareness in the community through media. This is one day pro bono week. This is 1 week, but on a daily, on routine, legal aid service providers are in media, legal aid service providers are in community, and they're doing what we call capacity building of the community or sensitization. We've had other interventions like open days, and where we call upon the justice actors, police, prisons, lawyers, and the judiciary, and we go into communities. We remember being funded by NSSF, DGF to do this kind of open days. And when we are in the community, they had the questions that Madame Nora was raising, and the judicial officer is mentioned by name. The judicial officer is there to even defend themselves and say, okay, I handled this matter, or please come to the office and we talk it more and more. The police will also be there to answer such questions. So the open days, and I remember the first initial open day again was here when I was here in Uganda Law Society Legal Aid Project in 2008, when we set up a desk at the railway grounds. That was the first open day when we began this model. So in a summary to the question, I must say we've been doing a lot. And some organizations are 50 years, plus that is FIDA Uganda. ULS is in 35 something, I don't remember. I used to count when I was still the head legal aid and pro bono. And many more, Foundation for Human Rights, SCTV, Mr. Nsubuga is there. Most of these organizations have been at this work beyond 10 years. But now the issue is, are we still as functional? No. We are no longer as functional because this was 80%, 90% donor funded. And the major donor was Democratic Governance Facility that was giving a basket fund, starting as the legal aid basket fund. And with DGF exiting, most of the legal aid service providers' performance has gone down because we don't have institutional donors providing the service. That takes us to the advocacy for the national legal aid law. That also began here in the Uganda Law Society, 2008. I recall when we visited the then Attorney General Hindi with the presidents of the Uganda Law Society then and the NORAD, Norwegian Bar Association, and we had a roundtable discussion. NORAD notified that in the 8 years to come, we are exiting. They were funding the legal aid project of the Uganda Law Society. And that's how we came with the national legal aid policy chaired by Honorable Helen, Justice Helen Ebura. And we provided technical support, and we produced in 2012 the national legal aid policy. We are transitioning to have the national legal aid law, and that's where we ended with the government. The policy has been at cabinet level since 2012. Then we went the private mover and worked with the Honorable Leandro Komakech under the Greater North Parliamentary Forum, and the law received first reading in the 10th Parliament under the leadership of the speakership of Rebecca Kadaga. That was the first reading. Come the 11th Parliament, it was not saved. And so the law now began afresh with another mover. Again, we moved and received a certificate of no financial implication, and the mover moved first to have the law receive its first reading at Parliament and referred to the Legal and Parliamentary Committee. The law had a provision for creation of a legal aid fund that would be now housed by the Uganda Law Council, where donors would input resources, government when they wish under the consolidated fund, and other sources of funding to fund legal aid in Uganda, but also have an institution like Justice Centers Uganda coordinate these efforts of legal aid and other legal aid service providers coming on board. Unfortunately, there is an argument, of course, by the Office of the Attorney General that the law still has financial implication, and therefore it contravenes Article 93 of the Constitution, and therefore he put up a preliminary objection at the second reading, and that is where we are. The Speaker has referred back to government, that is Minister of Justice, together with the mover to sort out that issue. However, unfortunately, that is where we are, and we are at a standstill. The mover is not concluding with the Office of the Attorney General. The Minister of Justice keeps promising we are getting back, and therefore, as I conclude, we cannot provide sustainable legal aid, we cannot provide sustainable pro bono services without a state-funded legal aid scheme. We are the ones lagging behind in East Africa. Kenya already has a law, Tanzania has a law, a policy is in Rwanda, is operating. Every African country, Namibia, Sierra Leone, every country has a state-funded legal aid law. South Africa is a model, and we went there. We benchmarked with the support of IDRO. Madame Barbara is here. We benchmarked with the movers and everyone, and then we came back having learned lessons in South Africa. South Africa Legal Aid Services, the government of Uganda funds South Africa Legal Aid Services, and it's run as a corporate. So I'm calling upon, as we celebrate the Pro Bono Week, I'm calling the leadership of the Uganda Law Society, that us, because Legal Aid Service Providers Network is considered civil society. The civil society has done its bit. But the mandate of the Uganda Law Society under assisting the public in all matters incidental and ancillary to the law is to support those who need justice more. I have noted 80% of Ugandans need justice. And we need the legal aid law. If we are to actualize that, I call upon you to take the battle. Let's get to the front line again and have that law passed. Thank you, Madam Leader.
Thank you, Dr. Sylvia. Our participants online and physically present, I think we hear the history of legal aid and its role in creating a functional justice system and in decongesting the prison's population and the strategies that have existed for over 20 years. Thank you so much, Dr. Sylvia. And she's actually highlighting where we went wrong. We no longer have funding, but also there is a problem of policy and law that must be attended to if we are to have a functional justice system that can lead to backlog clearance and decongestion of prisons. Our rapporteur, please take note of that. Thank you so much, Dr. Sylvia. I'll now shift to the Director, Monitoring and Inspection from the Uganda Human Rights Commission, Ms. Ruth Senkindo. I want you to pick it up from where Dr. Sylvia left it. There is mention in your reports of continued acts of torture while in police and prisons facilities, and further, the fact that most of these suspects do not have access to legal representation, which in essence delays the disposal of their cases. Kindly let us know what you're doing as a Uganda Human Rights Commission to ensure that acts of torture do not happen in places of detention and that these suspects have access to early legal representation as a human rights. You're welcome, Mr. Biansi.
Thank you very much. As a country, when we look at the criminal justice system and we look at ourselves, we are all candidates for prisons. And when we talk about issues of torture in our country, we look at government institutions. We look at prisons, we look at police, we look at UPDF, and other security agencies, including CMI and all those, we cluster them in prisons. When a crime is committed in Uganda, the tendency is that there may be mob action, or security takes it upon themselves to arrest. And most torture happens during the process of arrest. One, because we are raised as Africans to know that when you commit an offense or you commit a wrong in your home, your mother and your father, or your father punishes you, right? Now, that belief of punishment of someone who does wrong is also translated into the criminal justice system, where at the moment a crime is committed, the society, the community will feel the need to first punish or even ban suspects. Where that fails, then the investigative officer, the security police, during arrest and during the interrogation, then that is where torture often happens. To get quick convictions, to get information, it is also used as a form of investigations, but mainly as a form of extracting confessions or information from the suspects. Now, then we have the tail end, the prisons, because the courts many times look at suspects limping and they ignore, which they are not supposed to do under the Prevention and Prohibition of Torture Act. Now, when we look at the tail end, prisons interfaces with suspects who are injured. Now, if we're supposed to fight torture in our country, the whole criminal justice system has to be neatly cleaned up. Dismantled may be on the extreme, but I mean that there is need to empower police, train them, and also give them the resources to adequately investigate cases. Why is police resorting to torture? They're resorting to torture because of one of 5 things. One, they don't have the mechanism. By the time they invite a ballistic expert, a pathologist, I don't know, they don't have resources to transfer witnesses or even to fuel to go to the scene of crime to conduct investigations. So they're using it as a form of torture for a quick conviction to make confessions. 2, we are also looking at police. They are tired, they are frustrated, they're dealing with many cases, bored people. There's also sadistic tendencies where people enjoy inflicting pain on others. So where we have a police force that is like this, we need to see how we can clean out the acts of torture from our system. Now, what is the Commission doing? I think the Commission is the brainchild of the PPTA together with ACTV and other actors, we drafted the Prevention and Prohibition of Torture Act. And we believed that we needed an act, a specific act, to supplement or to ensure the implementation of Article 24 of the Constitution and Article 44 of the Constitution. So we could not use Article 44 and 24 that prohibit torture, because the freedom from torture is an absolute freedom that cannot be derogated from. And that is why we pushed for the PPTA. Then there is the Human Rights Enforcement Act that also comes into place to fight acts of torture. Now, I always argue that the freedom from torture and the existence of torture in Uganda is not because we lack the laws, but it is because of lack of implementation and impunity in our country. Once we address the issues of impunity, once as institutions, police, prisons, UPDF, CMI, we ensure that there is zero tolerance of torture in our institutions, then it will not happen. People torture because they know that they still retain their jobs. But if they do not, they know that they have a lot to lose, then there's no reason why they would risk it all to torture. So the other thing that we have done is visit places of detention, and that is prisons. Yesterday I was in Luzira. We were monitoring the prisons. So we went into the condemned section and just checked on the prisons, the welfare of the prisons. The issue of overcrowding cannot be overstated. The prison is full. Everyone has been talking about the 80,000 inmates. But beyond the number are human beings. If you go to Chitalia and the other prisons, there's what they call Chigali. They sleep on top of each other. Remember, the age group of our suspects, for example, we're still in Kampala remand. Kampala remand is where they take the petty offenders. And these are thousands, the 1,700. So you have a room like this and there are 4,000. And so they sleep like this, close to each other. So you can't sleep, the way you usually sleep. You have to sleep sideways. And if you're sleeping sideways, these are between the age of 21 or 20 to 35 years. And if they are between that age, then what happens? They get, they sweat, the bodies warm up. They get those things that men get. And, in the morning, there are issues. What is happening? What is happening? For me, I'm wet on the side. What is happening? So it is really amounting to violation of the right to human dignity. So as we're talking about numbers, we have to understand that behind those numbers, people had to internalize what I was saying. That behind these numbers is individuals. If you look at this room, when I walked in, the first thing was the pictorial on the walls, very fine pictorial. But when you look at the pictorial, what do you interpret of Uganda's criminal justice system? If you Google human rights in Uganda, everyone has a phone in the room and those online. If you Google human rights in Uganda, what comes up? It is pictures such as this: police brutality, UPDF dragging someone, people being choked, women who are being undressed and screaming. Is that what we want for our country? Is this the Uganda we want to see? So when we're talking about the criminal justice system, when we're talking about issues of human rights, when we're talking about the prevention of torture and ill treatment, it is for us all. But it starts with you, not only us lawyers, but the ordinary person. At what point do we say, no, this is unacceptable? At what point do we see police officers committing a crime or an offense, torturing someone else, mishandling someone else, and we keep quiet? At what point does everyone's voice come up? Because if everyone speaks, then things will change. But when we sit back and say, the drones are happening, you shall go in the basement, and no one speaks up, your silence is actually too loud. And it's because of this silence that impunity thrives. Because of this silence, there is a lot of wanton disregard for human rights and the rule of law. I think it is not about the commission alone. It's not about the judiciary or the DPP or every other person. It is about every Ugandan, and most importantly, we under the legal profession. I thank you.
Thank you so much, Ms. Senkindu. Participants online and present here, allow me to introduce our panelist who has just come in. Mr. Willie Biansi, the Deputy DPP, who will be representing the DPP on this panel. Thank you so much, Ms. Senkindo. She's speaking about the realities of our society. She's saying none of us have clean hands. Even before the person reaches the police, we are trying to do some mob justice about this person. She's speaking about the need to take a collective effort to clean up our system. But also she speaks to very good initiatives. Members of Uganda Law Society must pay attention to this. There is the Prevention and Prohibition of Torture Act. There is the Human Rights Act. What are we doing to sensitize people about this legislation that is meant to curb torture against suspects? Particularly because she speaks about the weak sanctions. What are we doing within the system? She's calling for collective action. She is calling for collective action as a measure to curb some of the torture actions that we see. She's saying we should all speak up. The Uganda Human Rights Commission is just one and a single body that we can all back up to come up against this. Mr. Biansi, the next will be going out to you. Before you walked in, we had a keynote address from Ms. Nora Owaraga, and it was quite heavy, particularly on the police, the DPP, and the judiciary. She called for dismantling of a dysfunctional system, and in that, she points at inefficiencies, improper and unprofessional behavior, delays, and dysfunctionality in a nutshell. But I also know in a nutshell, because I've asked panelists to sort of respond to her keynote address as they attend to their questions in these panel discussions. But also, that be the perception of Ms. Nora. We also know that the DPP handles an estimated number of, handles about 300,000 cases annually. Amidst a lot of understaffing and resource gaps. Kindly share with us what your office is doing to reduce the case backlog at your level as prosecutors, to avoid prolonged remand, and also to curb the unprofessional misconduct or any other complaints that come through to the Office of the Directorate of Public Prosecution.
Thank you very much, moderator. My apologies for joining in late. We received the invitation, but it was passed to me a bit late. DPP had personally wanted to be present, but she realized she had also to be somewhere else, in Mbarara at the launch of the Regional Court of Appeal there. I'm sorry I missed out on Ms. Owaraga's views and indictment. I don't know whether I take plea now or I'm already convicted. But for us as prosecutors, we get all this feedback in different forms. So it is not, those views are not new. We know the public we serve. They keep us on our toes. They keep on demanding for more and better services. Of course, as you've hinted, we operate under a lot of challenges, especially logistical resources and staffing. But we've been trying our best to extend our services to as many people, to as many places as much as we can. At the moment, we have about 146 RSA offices across the country. We have also opened up regional offices. Our target is to be wherever there is a high court, such that we enhance our presence and respond to issues that arise in the regions at a higher level. At the moment, we have 19 regional offices headed by very senior officers. Most of them are the rank of assistant DPP. So they attend to, among others, complaints against our RSAs in the districts. They respond to all these issues that were raised by Oraga. The delays, the unprofessionalism, and the quality of our services. We have improved. We have come a long way. For us as prosecutors, we feel we have really moved. Because many years back, you would travel very long distances to access even an RSA office. Many districts did not have our presence, but we have moved in at least trying to increase our presence. And now, even at a higher level, when we create regional offices, we reduce the distance that people come to Kampala to flock the head office, to raise complaints, and follow up their cases. So the regional offices are empowered to handle all cases that can be handled at headquarters. They supervise high court sessions, and if you have noticed, the number of sessions has increased across the country. Of course, partly due to the increment in the number of judges in the High Court. So much as backlog still remains with us, but we are also not seated. Another intervention we do through our regional offices is constant review of cases that are in the queue awaiting trial. Because doesn't serve any justice for a case to be in the queue for 4 years, 3 years, 5 years, and then at the trial, you enter null or a withdrawal. Our regional offices are directly charged with constant review of cases that are committed by the RSAs, awaiting trial to sieve out those that are non-starter, and we only remain with those that actually will proceed at the trial. The reasons for cases being categorized as non-starter are many. Sometimes people lose interest in these cases. Sometimes people die. Witnesses lose, we lose track of witnesses, or sometimes evidence fails to measure up. So we try to weed out those kind of cases before they are cause listed. So it helps to reduce on the backlog and also speed up the access to justice for the victims and the witnesses. In terms of professionalism, at the DPP's office, we operate a very elaborate complaints management system, which is headed by an assistant DPP at head office, but we also have mechanisms right from the lowest level. If you're not satisfied with the decision of a state prosecutor, you can raise your matter with the head of the station or the district, who is at the RSA level. Many of them are now senior at the level of chiefs and attorneys. And if you're not satisfied there, you can still raise it with the regional office. As I said, at the level of assistant DPP. And then, if still someone is not satisfied, then you can escalate it to the head office. We have had the incidences of unprofessionals of our staff, and we handle them internally. And those that are criminal, we can even prosecute our own. A number of them have been prosecuted in the anti-corruption court, and a few of them have been ejected out of the system. So we are alive to issues of professionalism, and we try to, as much as we can, or detected, we attend to them immediately. That's what I can say for now. Thank you very much.
Thank you so much, Mr. Biansi. I can see Ms. Nora is clapping at the response. And Participants here present and those online, Mr. Biansi is assuring us that there is a complaint system and it's functional, because he says the complaints keep on coming in. He is not denying the existence of some bad practices, which are only human and natural, amongst a cross-section of professionals, not only the legal or people who are employed in the justice system, but errant human beings are everywhere, in every profession, and also in members of our society. They are aware about that, and he says they have done a lot to ensure that complaints are handled even at a regional level. He speaks to the DPP coming up with strategies to serve the people more effectively. He has spoken of the regional offices, which are currently 19, with very senior officers to attend to complaints, but also to case management. And he speaks about the weeding out system, which for me speaks a lot in terms of clearing case backlog and decongesting prisons. And I think that is powerful. Thank you so much, Mr. Biansi. Before I go to the representative of the principal judge, I will ask the Uganda Prisons Service representative, the acting head of the legal department, to give us a voice on what they are doing to decongest or to ensure that the prison's population comes down. We shall be happy to hear from you, the representative from Uganda Prison Service. What are you doing to ensure that the prison's population comes down in light of the fact that the overcrowding or the occupancy rate is 350%. 350%. That is quite huge. Kindly share your strategies or sustainable steps that you're taking as an institution to decongest Uganda Prisons Service, with particular focus with the remand population.
I will begin by giving you the current statistics as at 23rd July 2025. We had a total of the number of convicts was 52.7%. That is 41,772. Those are convicts, which reflects as 52.7%. Then their remands. The remands are 36,865, which is a percentage of 46.5. We also have debtors who are 632, that is 0.8%, total of 100%. The total population as at 23rd July is 79,269 prisoners. So excess above capacity is 56,850, which is 353.6% occupancy rate. So as Uganda Prison Service, we have taken on a number of ways to reduce the congestion. Of course, the prisoner population is a major cost driver of the prison's budget. Therefore, the high growth rate of 8% poses a challenge in prison's budget in terms of housing, feeding, utility consumption, medical care, and staffing, among others. So, prisons holding capacity, which is the space that keeps the prisoners, has increased from 59,461 square meters, that is space for 16,517 prisoners in 2016, to the current 80,708.4 square meters, That is space for 22,419 prisoners. So with this current 79,153 prisoners, it means we are exceeding by 3.5 times. So whereas the population has reduced by 8.6% around 2016 to the current 46.5, the absolute population of remand prisoners has increased from 25,000 to 37,000, which is a 47.7% increase. And that trend is definitely due to congestion and the increase of the cost of access to justice, calling for more efforts to reduce the number of remands indeed in custody. So, to reduce this congestion, we call for, we are enhancing implementation of non-custodial mechanisms like community service, especially for petty offenders. There are people who should really not be with us if we took on all this that is available in our laws and we are not outside our mandate. There is what can be done. Then we also have taken on a strategy to construct regional minimax model prisons, the Kitalia type, all in the different regions of the country. These can have a capacity of about 4,000 prisoners each. So when we are calling for budget, this is what we are, for increase in our budget, we are looking at construction of these regional minimax so that we have one in the different regions of the country, so that we do not have only Kitalia. During the pandemic time, Kitalia Minimax suffered a lot of congestion because that is where all the people, including the political prisoners, were mostly being taken. So the other strategy is to construct 3 low security prisons per year using in-house labor and resources. The low security prisons, they may not be the upper prison level, but they can have these other cases. They can house other cases. I also, by the way, before I even proceed, would like to inform, because I had, during the activities of the week, they mentioned that among the prisons they visited was Luzira Prison. But Luzira Prison is 4 prisons, actually. There is Upper Prison, there is the Maction Bay, there is Remand, and the Women's Prison. That is just for information. So, those 3 strategies are what we have done for access to justice. Are what we are doing, it is ongoing. I wanted to say something about access to justice. Yes, we note that the judicial, there is increase. The courts of judicature are expanding, but the rate of expansion of courts is not matched with corresponding investment in prisons. So that means that prisoners are also walking long distances to court to access the justice. And the implication of this misalignment of prisons' locations to courts of law, apart from making prisoners and staff walk long distances, there is also high costs of fuel and vehicle maintenance and delayed production of prisoners to court. But to kind of tackle that one, our strategy is establishment of virtual courts or video conferencing facilities to reduce the cost of access to justice. We're also trying to acquisition of transport equipment for timely delivery of prisoners to courts of law, and construction of new prison units to complete the chain of justice. That is what I have to say for the moment. Thank you.
Thank you so much, Acting Head Legal Department, Uganda Prison Service. I love to hear from Uganda Prison Service. They're always ready with their statistics. And to legal practitioners, the ODPP and the judiciary, this speaks to something. They use every space that they get to mention the number they have in their custody. And they say it so gently that you may not get the message. But the message is, what are you doing about it? To me, each time I go to Uganda Prison Service, after the greeting, they will mention. Even to their own, they will mention. For me, I think deeply they are trying to speak to us about something. And of course, from all the measures that are the acting head of department, legal, is mentioning, they're reactionary to our actions, to what we are doing in the justice system, to what all of us are doing. To us, I will start with the Uganda Law Society. To us, the Uganda Law Society is sleeping around and not wanting maybe to give pro bono, etc. They are speaking to us. So all these are disparate measures because they are responding to something coming from somewhere. So that is food for thought, although thank you so much for the strategies. The virtual courts are welcome. The constructions of the prisons, I'm saying, oh, we are reacting to something coming from outside. But also they are making a call to us still, as the practitioners, the government officials in charge of justice institutions, that we are underutilizing the law on non-custodial sentences. And this I've heard from high-level prisons officials of you are sending us many petty offenders. So that is food for thought as we work on coming, on concluding this panel discussion. Is food for thought, serious food for thought, because she's saying the expansion of any justice institution is having a serious cost implication on them, and it's affecting, and the prisons population is responsible for the high costs of prisons running. Colleagues, we all pay taxes, so we are going to facilitating these big facilities. So we all have to do something about it. Thank you so much, Acting Head Legal. I'll conclude with our big brothers or sister, I don't know. I'll call them the big brother, judiciary. We shall hear from Her Worship, the Registrar of the High Court, Her Worship Prosika Tushabe, who is representing the principal judge in this conversation. And Your Worship, you're welcome. I will specifically request you to speak to the keynote address delivered by Ms. Nora Owaraga, and further to anchor in what strategies the judiciary has developed to clear case backlog and decongest prisons. I know there are several, but the outcry is still with us. It is still with us. We do not take lightly the initiatives that the judiciary has undertaken and all the strategies, but the outcry still exists. And we feel we can get some tangible answers, including guidance and recommendations to the institutions that feed into the judiciary. Your Worship, over to you.
Thank you so much, moderator. And thank you so much, Uganda Law Society, for organizing this, and congratulations on having your first event here. That's a milestone. And thank you so much, the keynote address, this bundle, whatever we were hearing. The panelists here woke up to listen. Well, for starters, I would like to say that the nature of the way the judiciary works is that if you're dissatisfied with a decision, you can appeal, you can review, that is one of them. But still, as a judiciary, we have a robust inspection team. I was waiting all along to tell me that, I went to the inspectorate, I raised my issue, and the inspector of courts did not attend to me. And then that would have at least piqued my interest as a registrar high court, because, we are there to do that and to follow through, or what was the solution. And if that doesn't happen, you escalate it to the Judicial Service Commission, There are ways where you can find a solution. You can pursue the legal, You can pursue, when you have an issue with the judicial officer, you can pursue that. But I'm sure at the end, there should be a solution or a decision that is made. So that's what I can say, that when you're dissatisfied, and appeals, I mean, I am at a lower court, the appeal court overturns my decision sometimes. Am I happy with the decision? Sometimes yes, sometimes not. Is the judge right? Sometimes yes, sometimes not. But it also goes back to the litigant. Are you satisfied? That is if you're able to get them. A good thing now we have our decisions displayed online or newly, so I can easily tell that, you know, these decisions of mine were overturned, these ones were appealed. So it's the normal way of working. The Court of Appeal can overturn your decision, and judges express themselves differently. They have a right to say some are kind, some are not kind. So it depends. But having said that, the judicial officer did the work. If you're not satisfied, those are the modes that are supposed to be taken, and usually it's not personal. Even if it's personal, then there are internal mechanisms to have it handled. And I also talked to what the last person said, that I'm glad now prisons are thinking about constructing prisons, because definitely the population is no longer as it was. And as rightly said, judiciary has overly expanded. And we are still expanding. I'm representing the principal judge because she's, I think, also on the groundbreaking of making a regional court of appeal, meaning that we are serious about access to justice and bringing the services closer to the people. That doesn't mean that we are not grappling with the challenges that you have here. So what are we doing? Of course, I want to bring us speed to the history of where we are coming from, that we didn't begin here. The reforms in the judiciary started, if I may say, in 2020. And I usually, when I'm in Law Society, I tell them the good thing is that Law Society, the members are the ones that come to the judiciary. We don't pick from somewhere else, we pick from here. So the people who are here are the ones who went the other side, and they are the ones making the decisions. Is that for a very long time, the judiciary was abandoned, and were heavily understaffed and also heavily underfunded, to the extent that I think a case to go through a system in one court, it took 10 years. Meaning for you to go through the system, you needed about 30 to 40 years for you to go into the system. Not because the system was bad, but because, I mean, those are the judicial officers you have. You can't do so much. And for us who are there in that system, you'd wake up and you look at your workload of 3,000, and even if I had one case, I needed about 25 years to finish all the cases before me. But we are glad for the changes. So what are we trying to do? We are trying to say, let's implement the principle of first in, first out. We are trying to emphasize it. Recently, there was a controversy about having that rule implemented, but we are emphasizing, telling our judges, our magistrates, please let's handle the cases that came in early before these other new ones that have come in, because that way we will reduce backlog. But if the case of 2025 comes and then I cause list it, and then that accused person goes away, what about the one who has been in prison since 2008? And with due respect to the urgency, to whatever happens, but that is what we are trying to do. We are saying now, since we have improved a little, let's also do that. Cause listing. I am glad the presenter said I speak last, because the judiciary does not operate in vacuum. We depend on what is brought. So I am speaking from the perspective of being the Registrar High Court. I'll deal with the cause list. I will ask, that cause list is supposed to be shared with prisons, it's supposed to be shared with DPP, it's supposed to be shared with police. We are talking about criminal justice. The cases are listed, and those human beings or whatever cases are supposed to be put together. What are we emphasizing? We're emphasizing that do it together, so that we do not have a case where prisons tell us we do not have the inmate. And you know, they also have their internal system. You are put in Ruzira, the next day you're in Chitadia, the next day you're where? You know, they have also their internal system. So we are encouraging and saying, please do that list together. Do that list together and say the 40 people who are going to appear in court, police has put in the input, DPP has put in the input, prison has put in the input. That is what we do. And now that goes back to down to the different courts. Is it being done? And if it's not being done, what are the stakeholders doing? You are a DPP, you've not seen a cause list, and the judge is coming, because we have visiting judges, and you've kept quiet about it. Somebody once said that the society can be transformed as much as they want to be transformed. Don't keep quiet. Say that, you know, they're going to start the session, but I've never looked at the list of the inmates. I don't have the files, and that's where the issues you're talking about of files. Because if there is preparation, a lot of preparation, and I want to say that we come from a society where we are learning to plan. It was not our nature to plan. But I want to tell you, what I learned when I was in the Law Development Center is that the case is won or destroyed at that level, in the law firm, whatever it is. The preparation is very important. Because when you come and you tell me you don't have a police file 3 times, I'll dismiss the case. Because now we cannot keep here calling the file for forever. And you know, that might be justice as a statistic, but is it justice to the complainant? Did they really get justice? We should be avoiding that. We shouldn't be encouraging that. But the system is in a such a way that that is done. So that's what we're emphasizing. We are also emphasizing plea bargaining. And of recent, we take the plea bargainings to the prisons. I had her talking about constructing new prisons. I hope you will include court halls, visual places, because now when we want to introduce audio visual in a prison, then they say, no, judiciary, you have to bring money to construct, we don't have it. So take the voice and say that the next prison should have, so that very hard criminal offenders, the judge can move in a comfortable court in a prison and handle. That when I want to hear the case in the comfort of my office, I can actually see the inmate, the lawyer has where to sit, the parties have where to be welcomed from. That is the modernity that we want to see, that you've made it easier for the cases to be heard. That is also contributing to decongestion. It's easier. You're telling the judge, for us, we have no problem. Stay in Kampala, don't ask the judiciary money, we shall put the people on the screen, and you look at them. But we are anyway doing that. Anyway. We are automating, but as the automation is gradual. It's not fully spread depending on the finances, but at least every quarter we add on courts. Every quarter we add on courts on automating, on doing INCMIS, integrated case management system, which we are putting in place, and I'm sure the prisoners, the people in Rosita know that not all the inmates now come to court. They use that. That is also meant to bring the making the measures to improve. And also, of course, when you automate, you do with so many delays. There are so many delays that you will note. The issue of saying that we are working with a file, we are looking for a file, that is going to be a part of the history, especially in the courts which are fully automated. For example, the criminal division is now fully automated. Do they have the physical files? They have, but I think in the next 5 years, there will be no physical files in the courts that are automated, because they will be phased out completely. But we do not now have new filings where you file with a physical file. So I look at things being better as we go ahead. Yeah, and I talked about disciplinary, that we do that. We also have a case management committee internally that monitors cases. I heard about the report that is being made. When reports are made, and the prisons people can say, when they bring us reports, I'm one of the persons that receives a lot of reports. When reports are made, we follow through on the reports. Of course, inefficiencies are there. People are so many, and the system is just beginning to get better. But when reports are made, we follow through the reports. For example, you find maybe somebody says, I've been in prison for 6 years and I've never been called to court. And then you go to find out what's the problem. Sometimes the problem is what I've told you. He was in Chitadia, he was taken to Nakasongola. And they looked for the inmate, they didn't see, or the file has not been brought, or a mispairing or something. When I was a chief magistrate in Machindi, I committed people after 5 years out of my own effort of what we call it, weeding out. You know, you reach at a station, you say, let me look for the files which are old and see what happens. So I got the file. Now, this was the problem. There were 4 accused persons, and that's a common problem. Then 2 pleaded guilty. When they pleaded guilty, they were convicted. When they were convicted, the file was put away, and every information concerning that file was taken because 2 people were serving a sentence, and the other 4 were forgotten. So we dug them out and finally found them, And when I interviewed them, they said, Your Worship, we don't know why our file was never called. Thank you for listening to me.
Thank you so much, Your Worship. You make me believe we need to have more forums like this to speak to each other and to iron out operational challenges. Ms. Nora, you're comforted. There are internal mechanisms. I think this is not only coming through the ODPP, but it's also coming through the judiciary. They have the inspectorate, they have the Judicial Service Commission, the appointing authority, they have mechanisms. But she also highlights more of how they operate, the first in, first out. If people are wondering why there are delays and they're having questions about this, the strategies, the ADR strategies that are being used, the automation that is dealing with a number of issues, including disappearance of files, but also a quick cross-check, but also the virtual courts as well come under that. She's speaking about the original marginalization of the judiciary in terms of funding that has had multiplier effects over the years. That is something that we really have to pay attention to, of the marginalization then led to all this, but she's giving us hope that is coming next to being over because the judiciary has been picked up as a priority area to attend to this. She speaks of preparation and planning, particularly for the advocates. She's saying she learned from LDC that the case is made and destroyed at the initial stage. That speaks a lot to us as ODPP and the practicing lawyers who sit at the bar. So that is something that we have to take away and to see how we can fix that. Nonetheless, I'll mention that all these mechanisms need to be disseminated to the court users. In the interest of time, allow me to invite the panelists in 2 minutes to wrap up the conversation, including responding to some of the panelists' presentation that touch their area of operation. I know there are some issues that have been raised and they touch the areas of operation of the various panelists. So this is the opportunity. Mr. Bianci, Dr. Sylvia, the acting head legal and the director in monitoring and inspectorate. This is the time to respond to some of the issues that arose. You could clarify, you could strengthen, you could add voice. I'll start with Dr. Sylvia in 2 minutes.
Thank you so much. As I wrap up, we are talking about redefining the criminal justice system. I want to mention, I mentioned that the criminal justice system is for prevention, punishing behavior, and rehabilitation. But we have made it more of a punitive system only. And we are forgetting other elements of rehabilitation, reintegration, to make sure that we abandon or we reduce on recidivism. I would like to really emphasize the issue of decriminalization of poverty. Majority of the people in prisons that are forming the numbers we are talking about here are people who have committed petty offenses, simple thefts, trespass here and there, assault, among others. So we need to make sure that we work around either amending the law to decriminalize poverty, which are reduced on congestion. We need to respect rights of orders in our different capacities as police, as lawyers, as judiciary, as prosecution. There is no need to arrest when there is no prima facie case. And when we arrest, we need to observe the 48-hour and the 24-hour rule for the children. We need to reduce on the prolonged stay in prisons. I have visited some of those prisons that she has talked about. Go to Kampala remand and you will be overwhelmed. At the level of prolonged levels of detention on minor offenses, when you go to Maxon Bay prisons, majority of people who are there are young people who are rounded up around these places, and they are imprisoned, and each time they appear, even when they have clocked the mandatory period of remand, the judicial office, as much as the numbers have increased, they will always say, further remanded, even where they can help and handle them. Police arrests on suspicion, even without concrete evidence. So we need to respect the rights of the holders and protect the pre-trial rights of suspects, and reduce on the congestion. We need to work on alternatives to prisons. Children are imprisoned as a measure of last resort. We should allow them to be on bond with the fit persons or the probation officers. And the others who have committed minor offenses, let us really strengthen diversion. Let us strengthen the community service. Let us work with local government on issues of supervision so that we implement that. Quality and speedy fair hearing, I can't re-emphasize that. We are using the plea bargain, but plea bargain for the statistics or for justice. What about involving the victims? Plea bargain should be carefully looked into, especially for the lawyers who are representing these suspects. A record of criminal conviction takes 10 years to remove. But someone can get it just in 1 hour of wrong advice. All of them running away from the situation because they want to plea bargain. Lastly, we are talking about building more prisons. But other jurisdictions are talking about building more rehabilitation centers. Today we have a wave of criminal justice victims, which we are calling suspects. Drug users, substance abusers, most of the offenses coming through is because people are robbing, because they are under influence. People are killing, people are fighting because they are under influence. So we need to think about rehabilitation system and strengthening it and reintegration into the community to reduce more of building more prisons and reduce on the cost. She has talked about the cost of defending taking care of a prisoner. We have a cost-benefit analysis, which we did. And it was looking at why should we have lawyers for legal aid service. We have even updated it. But at that point in time, prison, that was in 2018, when the cost-benefit analysis report was released. Prison was spending $3,500 on each prisoner a day, and I think it has increased. But we needed that amount of money for a year to operationalize, say, the justice centers and have legal aid lawyers who can move into prisons. Believe me or not, majority of the people in the prisons are because they don't have legal representation. And if they had legal representation and early advice, they would not be there in the prison. We are not going to talk about a fair justice system where there's no one to hold the persons that are charged or the victims by the hand. I will also speak for that because judiciary is expanding. DPP, in a short minute I will be concluding. DPP is expanding, but we forget about increasing access to legal services. Yet it is also a component of a fair and speedy hearing. I will wind up from there, and I thank you so much.
Thank you so much, Sylvia. 3 catchy words from her concluding remarks. Let us build a rehabilitative than a punitive system. Let us not overuse the justice system, alternative dispute resolution mechanisms, and provision of legal services. But also the fact that poverty has been criminalized, and that is real. I'll call upon Ms. Senkindu to give us her parting shots.
My name is Ruth Sekindi. I thank my fellow panelists for the insights. Today's dialogue comes at a time when we are celebrating the Nelson Mandela Day, and I'm glad we are having this discussion. And when we are talking about Nelson Mandela, we are looking at places of detention and the rights of inmates or suspects. But as we're talking about this, I'll pick it on from where our judiciary is mainly focusing on petty offenses. Should all petty offenses end up in prisons? And I'm talking about the ages of 20 to 39 or 35. And these are the majority in our prisons. You realize that they stay there for 8 years, 14 years, and they live a livelihood. They lose their youth, they lose their livelihood for life. So, and when we sit in as magistrates, many times we don't think beyond what is before us on the file. Yesterday when we were in prisons, the inmates requested that, can you please bring us some judges, the registrar, Madam Registrar, I shall be reaching out so that we do a visit to visit the inmates. And the DPP, because they were complaining about state briefs, and when one spoke about state briefs, you could imagine the whole Luzira making noise. They were saying, these lawyers, the state lawyers, are not helping us. State briefs. They said they come in, they're always adjourning, they're disinterested. You sit there, because they also have lawyers. There are many lawyers in Luzira, in prisons. So the lawyers are also empowering the inmates, okay? So if any of you is arrested, remember when you go to Luzira, you will be speaking the law to the inmates. So they actually know the law. So they say you sit there and you hear a lawyer representing you, and they're actually speaking nonsense. And they're saying, and this is the person who's, and when you try to advise them, they don't want to listen. We're tired of the state lawyers coming, not representing us for our capital offenses. The gentlemen who were on the death row inmates and those on the remands were actually very bitter about the state attorneys. And so we promised them, we said, we shall make a small high-level meeting where we shall invite the DPP plus some state attorneys, the registrar of the High Court, and we come in and just come and you talk to us. The ones on condemned, there are these issues of court-martial, transfer of files, those ones are in pain. And as magistrates, when we are sending in suspects and sending them, Chitari is full, Makshon Bay is full, everywhere is full. The prisons is overflowing. Last year, 2024, there's a time I went to prisons. Allow me to say this because we speak to reality. And when I went in, KCCA court had sent 89 women to prisons in Chigo. Out of the 89 women, 52 were pregnant. And and then the other 23 were, 52 had babies. And then the 23 were pregnant. Out of that 89, how do you sweep the street? What offense? They were begging, they were hawkering, oranges? Majority were Kejongs, people from Karamoja. So I said, this magistrate sat, and in his wisdom, he thought that the best way to deal with this issue of poverty and homelessness is to get 89 women, 53 of who are carrying babies, 23 are pregnant, and carry the burden to Uganda prisons, which is actually struggling. And I'm thinking, how did he think, or she think? What was behind them? Don't you realize that you're criminalizing poverty? Don't you realize that these are not criminals, but they are in prison because they are poor? At what point do we, as lawyers, as magistrates, when we come in positions of making decisions, do we put a human face and think human rights when we're making these decisions? There's also the issue of, let me just speak about pretrial detention. I know we are long spent for time. Every time we detain people for too long, because some were saying, I've been here for 14 years, I'm on remand. I'm here for 8 years. 8 years, 14 years, remind yourself, 14 years or 8 years from now, how old are you going to be? When you think about that, then you realize, oh, I'll be an old man, I'll be an old woman, my children will be. And you see, when you go into prisons, the first week your wife or your girlfriend comes. The second week, they come when they're hiding. No, the first month they come, they are busy coming, visiting. After a month, then the wife is only coming. After 3 months, she's coming in wearing big clothes. Most probably she's pregnant. After 2 years, she's not coming at all, and you're abandoned. This is the reality of the people we send in there, some of who have committed the simplest offenses where we can use an alternative without overcrowding prisons. Now, as human rights defenders, as human rights lawyers, we would not be saying build more prisons. But we also are alive to the reality that we have 265 prisons, accommodating maybe 80,000 at the time, but now she has said 79,000 men. That is the whole population of Mongolia in our prisons. That is our youth in our prisons. So when you think about that, And you're saying, what have they done? Can we put the people who are deserving in prisons? Okay, now finally, we are saying, let's not criminalize poverty, let's decriminalize petty offenses. Offenses like rogue and vagabond, okay, the court has ruled, now we are using common nuisance. At one point, every time we sweep the street, at one point they swept, and among the people who were swept in the streets was a judge, a former judge. And as they were taking him, he was like, you people, I am a judge. The police officer said, I'm His Excellency. Because they thought it was laughable that a judge would, but the good guy was having a walk, you see? So when we sweep the streets as police in total disregard, and then we end up throwing people in prisons, I think that is wrong. We should decriminalize petty offenses. We should make sure that we promote non-custodial alternatives, give bail. Let's use electronic monitoring. We should ensure that as lawyers, we do pro bono and represent clients. People are looking for lawyers. We are here. And let us have judicial oversight so that we know actually what is happening throughout the criminal justice system. Thank you.
Thank you so much, Director, Inspection and Monitoring. When you speak about the Nelson Mandela Day, it's something Uganda Law Society, you may want to investigate the history of imprisonment as a punishment in this country, and therefore redefine the criminal justice system. That is over to Uganda Law Society. I hear the same voice. Let us use ADR as much as possible. Let us decriminalize poverty. Yeah, it always touches me when I'm called to represent women at KCCA. And KCCA will not understand, but it touches me so much. Because usually, you know, they are taken into prisons, they leave children home. I've wanted to have a high-level discussion with KCCA over that. The issue of state brief, President ULS, Vice President ULS, we need to think about state brief. These are the lawyers that you've seconded to the judiciary to offer state brief. We need to undertake extensive training of state brief lawyers. There is a major concern there. Thank you so much for highlighting it. I hope also the Registrar High Court is listening to this conversation and is picking up this. We should discuss further. I'll now move to Mr. Biansi, Deputy DPP.
Thank you very much. In my conclusion, I would like to appreciate the Uganda Law Society for organizing this kind of engagement and the partners that you've worked with, because it is really quite good for us to be in one room and share these kind of ideas on common issues that affect all of us. For us as ODPP, we really have challenges where we need support from sister institutions and membership of law society, especially in the issue of staffing. The Chief Justice has been very helpful. Wherever he gets a platform, he has been really pushing for recruitment of more state attorneys. Because there are many courts that are coming up every other day where we are not represented at all, especially at the lower levels in grade 1 courts. There are so many courts. We are recruiting, but the judiciary is moving so fast. We need support. The Law Society is very influential. You have members of, some of you are in Parliament, chairing very influential committees. Please, we beseech and look towards your support in drumming up the need to strengthen the prosecution arm for us to be able to serve better. Maybe to respond to a few issues, on the issue of decriminalizing poverty and decriminalizing some of these petty offenses, really we also don't enjoy sanctioning some of the charges. But as long as they are on our law books, we have no choice but to implement the law as it is. So if it can relieve us, it will help us to concentrate more on the more deserving charges, and we leave out the petty ones that can be handled in other ways to the satisfaction of the complainants and the victims, because we also look at the interest of the victims. For example, on the issues of bail, as prosecutors, we don't enjoy objecting or blocking people's bail for the sake of it. But when we realize that many cases where people are granted bail don't take off, we also feel the pain, especially capital offenses. When people get bail, it's more like an acquittal. Our systems are not really very robust in tracking down these people to make sure that they obey the terms of the bail. So it is an issue that we need to address together with the judiciary and our colleagues, the investigators. Unfortunately, I've not seen anyone from Uganda Police, but they are the ones we rely on so much and to do investigations and tracking of these people. The issue of investigating after arrest is also a concern, but the police are not here. It is something that we keep raising with them as well, because it also puts us on a lot of pressure. It compromises cases sometimes when you rush to arrest and then investigate afterwards. It compromises the quality of the evidence and even biases the witnesses, and we even lose other potential suspects that actually would have been who are the actual criminals. But in the ODPP, we are adopting and popularizing an approach that we call prostitution-guided investigations as a way of improving the quality of our investigations and also speeding up the investigations. It also helps us to avoid those kind of scenarios of arresting and then investigating later. It is something that started in high-profile cases, especially in the anti-corruption court, but we wish we could do it in all cases, so that prosecutors are involved quite early from the beginning of the investigation of the cases. Such issues are handled as and when they arise, instead of files moving back and forth between the investigations and prosecutions, which is also another cause of delays in the system. I would also like to talk about the data hearings, which is at the Criminal Division of the High Court. It is also another mechanism intervention that has helped to reduce on the waiting time. Because I think for the Criminal Division at Kampala, they have greatly reduced the backlog. The oldest cases there are now maybe about 3 or 2 years. I wish the same could move down to even other circuits outside Kampala, where we are having a lot of cases in the queue awaiting high court sessions. As the number of judges increase and the prosecutors increase, it is something that we should think of adopting and supporting that as a way of reducing backlog in the judicial system. Because for us as prosecutors, the rate of committal is increasing. So basically, the high court session system is not creating a big impact, because they hear like 50 cases, but again, like 100 new ones come in the system. So with the time, the backlog just keeps rising and rising. So as we improve the efficiencies, we should also improve at the rate at which we dispose of cases, and one of them is the daily hearings, which should be taken down to other high court circuits. Thank you very much.
Thank you, Deputy DPP. I need not repeat your issues. They were very well articulated, but only to emphasize law reform. Uganda Law Society, listen, we shall charge the petty offenses as long as they remain so in the law books. That is some work for us there. To our development partners, we need to help Uganda Law Society undertake the law reform process. And also institutional strengthening is a key issue coming through. The DPP need to be strengthened, particularly in terms of staffing. I'll call upon the acting head legal, Uganda Prison Service, in 2 minutes.
Thank you, moderator, once again. I thank Uganda Law Society for the theme this year of redefining Uganda's criminal justice system. But here are some issues of concern that I'll leave us to ponder about. Uganda Prison Service has in custody people who are not supposed to be in prisons, and these include petty offenders on remand who have stayed on remand longer than the period they would have spent serving the sentence if they had been convicted. Then we have cases of indeterminate sentences. These are prisoners who are pending minister's order. We also have cases of conviction without sentencing, and this is common under the plea bargain system. Another is conviction without commitment warrants. Then there is long stay on remand after being committed to high court. That is undefined length of stay after committal. The average currently is 24.3 months. Then we have long stay on remand before being committed to high court. That is beyond the mandatory 6 months period. Those are my issues to you of concern, but also to give an answer to Her Worship, the registrar, on the constructions. Yes, during the constructions, there is consideration for modern facilities, for example, the court halls and the video halls. Yes, it is being put into consideration. The same with people like the disabled, and putting into consideration all these factors. We are not just constructing the way most of the prisons that we have, the very strong prisons, were constructed several years ago. So they are very old. The styles were of then. Thank God they are strong, that they are still housing, but the style was not up to date. So with the current constructions, yes, we are considering all these modern factors. Thank you very much.
We should have started the conversation with the head legal Uganda Prison Service, because she seems to give strong pointers on why we have prisons congestion. And I'm glad that the representative of the principal judge is speaking last, because these are issues that she will directly speak to. We thank you for your patience. We shall have the Registrar High Court give her parting shots.
Thank you so much. I'll start with the last one, that petty offenders. I'm sure we all know that we have a Community Service Act that is very old, that is archaic and unapplicable. So Uganda Law Society, what have you done that? Because petty offenders are supposed to be catered under that. We also have a section in the MCA that talks about reconciliation. If I've slapped my wife, should I really be in prison for 3 months as I'm waiting? What happened to applying Section 160 of the MCA? Reconciliation shall be promoted. It's not only for civil cases. The keynote address is looking at me and saying, yes, it is there in the law that reconciliation should be promoted. So you can promote reconciliation. In deserving cases, I'll put a disclaimer. It's in deserving cases, not in all cases. Yeah, but the issue of petty offenders is something that we need to address. And I will talk about community service. We are saying we decriminalize poverty. I agree. But I want to say, as a person who used to work in one of the most populated places, Machindi, it had Katwe, it had the beach. You find 90% of the people have been arrested. They don't have any particular place where they live. No fixed place of abode. You want to give community service? And there's nowhere where these people come to report, to do the work. That makes it difficult to give orders when you're not sure whether the people will come. But anyway, in instances where you have a community that cooperative, they say, oh, we can take them to KCCA, they can do some little bit of work, but still a lot needs to be done in there. I'll talk about the daily hearings, and the DPP has talked about them at the criminal division. I thought I'll do it as a parting shot to say that while you're talking about making changes, I think the judiciary has already gone ahead of you, and we already have a very major change to say that we move off from the session system to the daily hearing. but we cannot implement it all through at once. But there is a discussion to actually roll it out to about 3 or more forecourts and see how they perform. I'm sure, as I said, over the years, we will soon have no session system, and we will go to daily hearings as DPP continues to, because daily hearings requires a lot. It requires that each judge has a DPP, has a state attorney appearing before them. And as already know, some courts up country, they are sharing, 4 courts sharing 1 state attorney. So you can't implement something like that. But at the criminal division, it's doing well. We will soon roll it out to other courts so that the period reduces. I'll talk about criminal justice being a chain. I mean, you need police, DPP, you need prisons, you need the judiciary, you need the lawyers. And every other time when part of the chain does not perform their role, then there's a problem. So I call upon the actors, let's work together. We have stakeholder meetings where these issues are supposed to be raised, and they should be raised there. I'll talk about ministers' orders. And I want to say, with no shadow of doubt, that prisons you've not brought to the attention of judiciary if you have pending people with ministers' orders. I'm saying that because that is my role. So I don't have any pending ministers' orders on my table that have not been attended to. And this is the second time it's appearing. Masaka raised it. Kasese has raised it. You're raising it the same time. I don't know if I should be writing to your boss to report that you don't want to send the names. I don't know. Because there's a problem. You know, there's a blame game. But the actual truth is, if we walked away from here, I don't have any pending. The people I found pending in my office have all been worked out on. The minister has given the orders, and the minister is not. Actually, let's clap for the minister. He's been very good. Every time we give him a call and say that these people have come, he will work on them. So now the problem is still down there. I don't have any pending list on my table saying that these people are pending minister's orders. Otherwise, would have raised it with the minister now, and the minister would have worked on. So we don't have. And the list of all inmates pending minister's orders is submitted to my office. So I'll be waiting for it after here to work on it. And then I'll talk about the legal aid. I want to say that the legal aid is no longer as felt as it used to be. And I'll talk about pro bono. And say, you know, Uganda Law Society, you have people who are doing pro bono. I've never seen in the courts where I used to be. It is the litigant who would come and whisper in my ear once in a while, you know, Your Worship, that lawyer, I got him from Law Society. We are not paying him. At a certain stage where maybe I have been a little bit tough and said, why isn't your lawyer coming? Why isn't he here? I'm saying Law Society. If you have lawyers and you're confident that they're doing pro bono, send the list to the judiciary and say the following lawyers have offered to do pro bono service in the so that we feel that you are there and there's something that you are doing. But beyond that, you're full of buffet, like he said, and the buffet come from you. And another thing I want to challenge you, your members do wrong things. For us, when we do wrong things, we've told you where we go. It is rare to see Uganda Law Society coming up and saying, we dissociate ourselves with this member who did ABC. You don't put out those statements with due respect. I've never seen any statement when you are saying that our member who did ABC, we disassociate. So sooner or later, you are buggled up into certain, you're creating a certain atmosphere that is not very good for the society. Disassociate yourself with those people. Somebody has been convicted, you're quiet, and he's your member. Somebody's impersonating for years at the court. We put up a signpost and say, this person is Amufere, please when you come to this court, don't deal with him. But the people he's impersonating are comfortable with it. Can we do something about it? I leave it at that. Let me talk about the issue of state brief. I am the secretary of the state brief meeting, which the vice president belongs to, the moderator belongs to, Dr. Sylvia belongs to. Now, the new law has forms to put complaints. So if you're here and somebody has complained to you, get the law, print out the form, give it to the accused person, let that accused person give their complaint and bring it to me. It's me who keeps the roll. That person will be removed on the roll. And as I earlier said, what are we doing to help the judiciary to do their role? I will not come from here because now you've told me how difficult, and then I say, I'm running to the prisons, I'm giving them the forms. The forms are there, judiciary has done its part. It's given the forms to say if you're not satisfied with the state representation you're getting from the people we are paying, kindly make a complaint. They are there. So I ask the prison officers, the human rights, civil society, take the forms to the accused persons, print it out, or share it with the prison authorities. And instead of us ranting, let's deal with individuals and clean the system together. I don't have any single form of a complaint against a lawyer, otherwise I would not have initiated that person would register them on the roll and say, we have received 6 complaints from 6 officers. Do you still want to really give state brief? I think you go and look for money. You do not have a heart for the indigent. So I'll leave that there. I'll talk about beyond 6 months imprisonment. I came earlier on with an administrative circular number 2 of 2024 by the principal judge. It is on our forums and on Yuli that, let's use it. It talks about people, when people have clocked the 180 days, the prison authorities are supposed to get the form. The form is attached to that administrative circular and give it to the inmates to fill it, and they are supposed in turn to take it to court for the judges to hear. What are other people doing? Of course, it's judicial activism. I don't know about civil society activism in that area and also law society. Because, I talked to some chief magistrate in Nakot. He told me, I get a lawyer who is willing from a legal service or a provider to go to the criminal division, file for me the applications, and after he has filed the applications, then I send the files. But in some instances, nobody is initiating that process. But the form is there. It's very clear. It talks about unrepresented litigants to do that. But also, legal service aid providers, that is your role. Somebody has clocked 180. There is a clear guidance that this is a high court case. What is being done? The form is there. So I call all of us in the room. Let's act. And let's hold judicial accountable after we have done our role. That's why I speak last, because everything we are picking from what the rest are doing. And we are asking that, we are lawyers, we are evidence-based. And most of the instances you want to act, but there is no evidence, or there is no things that have been brought to your attention. But I know that the judiciary has done something to improve. That was also something to improve in the criminal justice system, not to just dismiss people, but give people an opportunity, because it's a murder case. And then the next day, grade 1 magistrate, a grade 2 say, you walk back home into the community. So let there be some processes, but let's work together to improve the process and also improve the criminal justice system. Thank you for listening to me.
Wow, thank you so much, Your Worship. Members, participants, it's a call to pick up on the initiatives. And personally, I pledge, Your Worship, I personally pledge to follow up on the cases of pending minister's orders, how I'll approach Uganda Prisons Service. I'm happy to contribute to that. Maybe to note that not all imposters are members of Uganda Law Society. They are imposters out there. And I think previously I've seen Uganda Law Society saying this one is not our member. But also our members who do bad things are subjected to the Law Council. Unfortunately, we don't have a disciplinary mandate as Uganda Law Society. Instead, we have an advocacy mandate for our own to see how they are not disadvantaged in places. But I know many of them have been subjected to Law Council proceedings. Maybe we need to now highlight the imposters of this one is not our member. And who is our member? Our member is a person who has paid the annual fees. If they have not paid, we shall disassociate, I think, Mr. President. We have been called to strengthen on that. Thank you so much, Your Worship, for pointing us to all the initiatives in the judiciary. Colleagues, I call upon you to pick up on those initiatives. Together we can redefine the justice system using the initiatives, even using the existing law. I step down as the moderator of the panel, but I'm not disbanding the panel. There is yet a question answer session that is to come, and I think the panelists will be responding. That is going to be chaired by Mr. Asmani Matovo. Kindly take over from me.
Thank you very much, Ms. Lydia, for this wonderful moderation session. I'd like also to thank our dear panelists for sparing time and give various insights in regard to various issues that has been raised here by the different members. However, we are entering into our session of question and answer, and this will go to the plenary. We have limited time. We'll just request a few questions within a span of 5 to 10 minutes, then we go to another schedule. Council Eddie, you will assist me with the microphone. Let us proceed.
Thank you. I'm Christina Ori, and I'll speak to prisons. Maybe the other people they didn't mention who they are keeping in prisons are the Karachunas.
Yes, I think let us get all the questions, then they answer to us. But the first one has been addressed to prisons by our CEO about the issue of the Karachunas. Madam CEO, clear highlight on who are the Karachunas.
These are the Karamojongs who were arrested, and after that judgment of we received in January from Supreme Court, I thought you would also mention that those people are also causing congestion in the prison. Maybe I'll also speak to state briefs. We have judges who have tagged lawyers to themselves, who they feel they want to work with on state briefs, and other lawyers who are young and vibrant, ready to work, are not given time to work. And these also include legal aid lawyers. Thank you.
My name is Robina Chamuhangire. I have a question towards the registrar. I am aware that case backlog has become one of our biggest problems, both the judiciary and us, the practicing lawyers. But my question is, do we have an evidence-based system at the judiciary for us to be able, for instance, to track the effect, for instance, of the new courts that are coming in place? We have new high court circuits. So many of them, I think, recently have come in place. I would be very interested in knowing, for instance, in the next 2 years, how shall we have decreased the case backlog? Because we want to see, is the increase of judges and the courts actually working, or are we going to still seeing the same question 5 years to come, that we are still having a skyrocket case backlog going up? I need to see how we critique ourselves using figures. That's my concern.
Hello, yes, good afternoon, everyone. Uganda Law Society, so much for being a safe space for freedom. Now, this is my question. By the Sam Shamil. We all know the pro bono thing. You people, you have tried it. It's not working. Thank you for the suggestions. Why can't we disband the entire pro bono, this thing, and create an office of the public defender? The way you have the office of the director of public prosecution, we disband whatever models we have right now, create the office of the public defender. It would be fully funded, the same way the DPP is funded. That person would take oath, be sworn in, and handle majority of these other things. And I've told you people from time and time again, the judiciary is where justice goes to die. Human Rights Commission is where human rights go to die. Equal Opportunities Commission is where equal opportunities go to die. Uganda Law Society, as they said, some of your members, yes, Uganda Law Society is also where the law goes to die. So, can't we revamp most of these institutions and create a functioning system? Increasing the number of judicial officers will not help us if they are all lazy. The lawyers of Masaka went on strike, not because they didn't have judicial officers, but because they had lazy judicial officers. So, what mechanism do you have to ensure that even the lazy people that you hire, honestly speaking, are worked on? Because we have made complaints. You said Inspector of Courts. I made complaints against Justice Sekana. I was vindicated by Justice Chirawire's ruling. After so many complaints about him, Justice Chirabire vindicated me. So, can't we create a comprehensive revaluation, not patchwork of putting a plaster here, a court there, a DPP here, a state attorney there, a law society member here? That doesn't work. And finally, for prisons, I would like to thank you. Of all the government institutions, I usually don't give credit, but you have been professional. You have done well, and I think, honestly, you deserve a hand clap.
Good afternoon, everyone. My name is Joyce. I come from the Uganda Association of Women Lawyers. One thing I wanted to ask the Uganda Law Society, do we have an outcome document out of this? And Anthony, this is something we shall hold you to account, because we can't have a symposium like this and we are not hearing of any outcome document, especially when it comes to advocacy for criminalizing petty offenses, because most of them actually affect the marginalized and the most vulnerable in our community. Then the other thing I needed to really emphasize is the plea bargain system in Uganda. I happen to be one of the people who usually offer legal aid in the prisons. And it's very, very heartbreaking. And so often, the conviction has already happened. So there is nothing much you can do except appeal. And we all know the system of appeal in Uganda. So I needed to re-emphasize this. But also something I needed to bring to the attention of the meeting is we often don't speak to culture when we are in meetings like this. But anyone who has worked in Karamoja knows that even after you've served your prison sentence, you are still going back to serve the community kind of sentence. And I think this is something that causes some people to actually commit more crime, because after you've served, you go back to maybe wherever you come from, your home has been burned, something has happened. And these are things that the criminal justice system doesn't take consideration of. Even the judges don't look at some of those things when they are deciding their sentencing. And then if we do not have the police in this meeting, I think sometimes we are probably wasting time, especially that we are talking on a theme on redefining the criminal justice system. Police is one very key actor in this system. And one thing I've found is the negotiations that they actually have at their level, and so many of those things that they're actually perpetrating. So this is something Law Society has to do even beyond this. How do we re-engage the police, especially in some of this? And of course, I can't restate the National Legal Aid Bill. It is very urgent as I don't know when, because at the moment we don't have anyone funding legal aid, and even when her worship stated that she doesn't see legal aid service providers, it's because we have really come down to which district needs us the most. And when we look at the strategic plans of the development actors at the moment, most of them are going to West Nile, Karamoja. West Nile, Karamoja. No one is talking about Kampala. No one is talking about Western Uganda. Because, of course, when UBOS releases its statistics, it's going to mention that those areas are rich. And those are places, when we are having symposiums like this, can we have everyone in the room? The National Planning Authority, UBOS, can you be in the room, and every other person? So some of those are my key recommendations, but Anthony, I'd want to hear on the clear outcome document of this meeting. Thank you.
Thank you very much.
Thank you so much. My name is Robert Jurua, ULS staff. My question or recommendation for that matter is to do with the online court sessions. We have had challenges with the courts of judicature. The schedule online court sessions, and yet on the day of hearing, there is nothing that is going to happen. We communicate accordingly. We go to court 9 a.m. You're seated in court up to around midday. Nothing is happening, and the prisons officers, of course, are already telling us our clients are nowhere, right? Because they are supposed to be online, maybe in the prisons. And the court is also saying there is no network, there is no space, whatever they call it. We're wondering why then was this infrastructure created when we were not ready. But in the alternative also, not to be very harsh, because we know it's a technological world and it's going to happen once it gets into place. Why aren't there adequate solutions to when the prisons and judiciary are not in position to effectively offer the service of online court sessions? Because at the end of the day, we don't get so much time with these inmates. We don't have so many court appearances, and that very little opportunity that is there, the prisoner, the family, and all those that are related to the person are very anxious. And of course, it also affects their mentality. It affects their psychology. Why aren't there some solutions to these issues? We know they are there, but there's nothing being done. We're just told adjourn to next week. We had a case with a colleague of mine here right now in Machindye. A gentleman was in prison for over 6 months. We were trying to apply for mandatory. And, nothing happened for over a month or two. They're just telling us online, nothing has happened. We are quite disappointed, but of course, this might be the best opportunity that we have representatives from both institutions. Thank you so much.
Thank you very much. I think let us have the last person for the interest of time.
Good afternoon to all of us. Thank you for the opportunity. My name is Gloria Nantume, and I am a clerkship student as well as a student of the Legal Aid Clinic from LDC, the Mbale campus. Mine is more of a concern, and I think to address it to our panelists. Whenever we go to prisons to get information from prisoners, we happen not to be the only legal advisors that go there. So you find that whoever goes to the prison wants the documents that the prisoner has, and these documents act as identifiers to these prisoners. So you go there, ask the prisoner for their CRB number, court case number, and they don't have that information. So mine is a concern that goes out to all the legal aid service providers, that whenever we go there, let us not take these documents from these prisoners, because whenever we take them, we leave them without an identity, and there is no way we can help them. If at all another service provider goes to them, they don't have any way of being helped. So I think that also contributes to someone being on remand for a very long period of time. Thank you.
Thank you very much. From online, there is one saying that judicial officers known for not hearing bail applications, some are known for not exercising their judicial discretion to grant bail, and in case a lawyer pushes much for hearing of the application, especially in the countryside courts, such judicial officers contribute greatly to criminal case backlog. Another one has said lawyers too should be blamed for case backlog. They enjoy blaming others. Some are lazy, unprofessional. Some are deliberate delay cases for baseless reasons, dishonest dealings, among others. Another one has said there are issues to do with ECMIS, which is a challenge being faced by some of the advocates. Another one has said that some of us are on the role of state brief for many years, but we have never gotten a chance to participate. Why? Those are some of the questions or concerns from the members online. I think we'll begin with our prisons. The first question was in regard to the issue of the Karachunas. Those are the Karamajongs.
In answering that question, maybe I'll let the member know that I did not mention all the offenses that we have. If I was going to mention, maybe I would have listed that we have aggravated defilement, murder, those that were on robbery, that kind of thing. Probably that's what she wanted, to list. Because when we are giving categories, our categories are the ones that the convicts, the remands, and the debtors. So you fall somewhere among those. That is what I would say in reference to that. But the other one was thanking. I appreciate that, and we as an institution also aim to always improve, of course, as we work together as partners in this. It is not it's not about a person, an organization showing that it is doing more work, but we're just working together all to make our country, to put our country on a better map, to fulfill the mandate of our country. Thank you.
Thank you very much. I think this would go to Ms. Rivia in regard to the disbandment of Pro Bono and creating an office of public defender.
We welcome the recommendation if at all it goes in improving access to justice, but then we have to first outlaw the advocates' regulations that make lawyers to provide the 44 hours of pro bono, which is a legal requirement, but I really welcome the proposal. It's long overdue when we don't have a public defender's office. And that is the model I shared of South Africa. It's a public defender, well funded by the government and well resourced. The lawyers grow to the level of practicing at Supreme Court. Then they have staff advocates that the trainees right from law school. There is professional growth. They have commissioners. They have people who have received awards and they're very good litigants. They've grown and the profession has been professionalized to the extent that people are craving to work with Legal Aid South Africa. So you will find that if we grow these public defenders, first and foremost, our lawyers that are being channeled will get employment. We reduce on the flooding of the many lawyers who are not doing much and are also getting to be impoverished because there is no work and there's no employment. So I really fully support it, and also the call to enact the national legal aid law. We are now 15 years on a law that is going to benefit the majority of Ugandans, and we are begging. The way health services are important, the way road work is important, is also the way access to justice is important. And it has a cost-benefit analysis that is both social, economic, and political. I want to invite the lawyers to read that law, that research. You will see the benefits. Even we shall increase the 20% that can access private lawyers. They will be increased because there will be a multiplier effect, and we improve the economy. Thank you. Then lastly is the other point raised by one of our long lawyers, that legal aid service providers should not take away documents of the suspects. That is very important. Until someone says you represent me, but even when they say you represent them, there are certain documents you leave with them so that they can make reference. So we've taken note of that, and we shall work within our networks to make sure that is corrected, of course, working with prisons. Thank you.
Thank you very much. I think let us hear from our Vice President in regard to the concerns raised to the ULS as we conclude with her worship in regard to issues to do with the judiciary.
I'll speak from here. Thank you very much for the concern. I'll begin with the request that this doesn't stop here. Now, the reason we did structure this engagement the way we did, the reason we said it is one of a kind, the very first one, is the intentionality of where we want to go. Before we would talk and stop there, now the discussion we're having right now is for purposes of continuity and policy formulation. While discussing, I talked about our mandate as the Law Society to advise on policy, on legislation, and some of the recommendations you had here point to policy reform. they point to legislation, the laws we have in place. I had our Worship Kare say, if even the deputy DPP, that if these laws are still on our law books, for us we shall charge. That is the law. So where do we come in? What is our role? So the recommendations we intend to come out with is the document here. That is going to guide us. And the members we have here, you heard Mena was presenting about our alliance against electoral violence. We intentionally came up with a document where different people committed themselves. We shall require a commitment from each and every stakeholder so that we have some kind of tracking method where we know the person responsible for this is maybe judiciary. The person responsible for this is a DPP. And we keep tracking, following up. This is not the end of this discussion. We need to have more, and most importantly, we need to take action from what has been discussed here. And we shall actually share the report, the outcome of this with each and every stakeholder here. And we have a clear tracking mechanism so that what we've started here doesn't end and doesn't be in vain. Now, I'll talk about an aspect of, he talked about errant members and the fact that we have lawyers. It goes even back to the state brief and even other lawyers. One thing you need to know is that the current legal regime we have is you have the government-controlled law council, which has literally usurped the role of the bar. And it has been one of our cries. We're saying as the bar, following the IBS standards, we should be independent. We should be the ones in charge of policing, controlling, and even disciplining our own members. But now that role has been statutorily, by law, given to the law council. And our role, actually, when you look at our act, is to protect, defend, including by even those errant ones. So you find we're like the lawyer's lawyer. But in our vision, and what we've been saying is, in continuing to fight for the independence of the legal profession, the independence of the bar, it involves even where we call out our own, where we come out. Because right now you cannot even openly, challenge the actions of the law. They will tell you it is the role of law council. You do not have that mandate. But in our vision, we keep talking about the vision 2060. We want to have a bar where it is the law society in itself in charge of its members, doing everything, including disciplining the members, calling them out, and taking charge. And this takes policy reform and amendment of the law. And in our term, we are hoping to challenge this, to have an amendment of the law to make sure we are in charge as the lawyers of our own profession. And that is where we can make sure that we protect our own, even the ones who are trying to tarnish the name of the profession. It's a policy issue, and we can assure that we shall work on it, and we'll deliver on that, hopefully, by 2060. That's why we call it the Vision 2060. But again, we also pray that it can come closer, because we believe this is time for action. When we are talking of dismantling, for us, we use the word radical. Why we use the word radical is because, there are some reforms that are required. But because of the nature of the way things are done, the bureaucracy, the red tape, when she was giving her keynote address, she was telling us the offices she has been referred to. You go back, they send you back. You go back, they send you back. We are saying there has to be an end to this, and the time for action is now. That's what we are asking every other stakeholder we have here. Let everyone do what they're supposed to do at their desk, and we shall be guided by the outcome of this conversation. Thank you very much. Maybe you talked about police not being around. I can assure you we did invite them. We did follow up, because our intention, that's why you see an empty chair here. Our intention was to have each and every important stakeholder in the criminal justice sector, so that we discuss. We don't want an issue where people are going to say they said all these things in our absence. Our worship was able to respond to all the other concerns. Prisons was able to respond to other concerns. Uganda Human Rights Commission did the same. DPP and the legal aid service providers. But now the fact that every point, the criminal justice system begins from police. He talked of prosecution-led investigations. It is not the DPP who conducts investigations. It is the police. But we believe it should be on the guidance of prosecution. But we don't intend to stop here. We shall continue, engaging. And we shall also actually make sure the outcomes of this engagement are prepared and served upon the police. And we shall still go ahead and call them up to see. Maybe in the next discussion, the next roundtable, we shall have them and say the last discussion we had, ABCD came out from the department. Can we please sit and we have a response to this? So we don't intend to stop here. We are taking a radical agenda, radical reforms to ensure that we have a better criminal justice system. Thank you very much.
Thank you very much. Lastly, let us have our dear registrar, our worship, to address the issues. In a brief, the first one was in regard to state briefs, where judges prefer specific lawyers. The second one is about the laziness among some judicial officers, even if complaints are brought forward. The other issue is to do with online court sessions, where they are scheduled, but there is no business on time. The other issue is to do with judicial officers known for not hearing bail applications, and some not exercising their judicial discretion. The other issue was to do with whether there is a possibility of doing an integrated system for both the old cases and the new cases. Because from your presentation, it suggested that the intention is to deal with the new cases, and the member was concerned, seeking to know whether there can be an integrated system where we can deal with both the old and the new cases. And then lastly is about the ECMIS, delaying cases, and also a challenge to the lawyers or advocates.
Okay, thank you. I'll talk about the delay and INCMIS together with online court services. During COVID is when most of us were introduced to online hearings and having meetings. And I can tell you some meetings had to be called off because of the challenges of network, the challenges of unruly members. You tell people mute, people don't mute. You tell people listen to the presentation, they're not listening to the presentation. Videos are going on and very other serious scandalous activities are happening. So it takes me back to the challenges of this society when it comes to introducing technology. That those challenges we are grappling with, the judiciary, it derives its membership from this Uganda. We are not non-Ugandans, so we are facing the same challenges. You're listening to a case, the network goes off. Is it a role of judiciary to do the network? No, there's an institution in government established to handle that network cable that we are using. So the judge is stuck. We are working hard to improve that, but I want to tell you that when new systems are introduced, and which we are all grappling with, there's a time you go on your mobile phone and you want to talk and you hear other persons talking in your phone, or they say the telephone number is wrong. Our challenges of technology in this country are immense. And of course, they've also gone to the courts. We also introduce a system and we start struggling to put the system right. But we have a technical system in charge of INCMIS. I don't know if Law Society has a technology cluster or something like that. Like usually, I give example of the courts who have been. I used to deal so much with the family cluster of the Law Society. So they would put back together all the issues they have with family, with the family court at Machinde, and they bring them to me and we discuss. So if you have that technology team, I ask that we put them together and then bring them. Then that committee, the technical committee, will look into what is that is possible to reform and change. Bearing in mind that issues of network, issues of old machines, those are issues that are beyond the judiciary. But I'm sure the judiciary will do something to improve. INCMIS is a good system. CAS is a good system. Let's support our system. Let's support the judiciary. It is our home for everybody, the stakeholders here. That's where we all go to say that, okay, how do we improve it? I don't want to say that the challenges are not there, but the judiciary is working. I'm sure nobody has raised issues to do with power. You should clap for us. We've improved in that area. Some time back, court would stop because there is no power. But now we have generators, we have solar. We are improving in all areas. And I'm sure also the INCMIS system will improve, and then online court systems will be good. State brief, I want to say that the rules were introduced for state brief. And the role was created immediately. But when the role was created, it did not have a financial implication. I had people using some statement. There's something they say maybe financial implication. We are supposed to be paying according to the cases that are being handled, but at the moment that is not happening. It's something that needs to develop by the funds.
So when we say that everybody on the roll is going to be given an opportunity, you know opportunity comes with payment. So that is something the committee is still grappling with. We are still working on it to see how to improve on how the funding, if the funding, government increases the funding, how do you increase the lawyers? Because there's no way we are going to increase the lawyers when we do not have the funding. So the role is there. There is work that is being done. We recently had an online engagement to discuss about the rules, and I'm sure things will change over time. But at the moment, it's impossible that we will have many lawyers channeled in because the payment is not commensurate with what is put in the rules. The rules are just being implemented. Talk about judges and magistrates who do not want to hear bail application. This is something that you need to raise, if I may say, because it varies from individual to individual. I can't say that all judges, all magistrates do not hear bail applications. There are some who do. But when you have a challenge, like earlier on we said, there are systems on how you can raise that and say, but you know what, every time, this is a pattern we have seen in this court, and I'm sure there will be some interventions that are being made. Somebody has raised that before. I sit on the disciplinary committee, so I know that those issues actually can be handled on what is happening. And sometimes it just takes a little bit of letting the person know that what you're doing is not right, or there's a complaint from the stakeholders, and that's happening. You need to improve here. But also in the meetings where the lawyers, prisons, DPP meet, why don't you raise it and say, but you know, this is the trend that we have seen. Needless to say that I'm not watering it down. I'm saying we hear sometimes somebody is saying that this person, this certain judicial officer didn't grant bail. But when you bring it to attention, we will work on it. And I'm sure also they are also hearing, they know that that needs to be done. Integrated system for new and old cases. I can't speak that for the judiciary. Somebody asked about backlog. We are trying to fight backlog. What is backlog? Backlog is an old case. So how do I handle the new case and then I leave the old case? That is where the challenge is. So the integrated system, there's some that maybe they consider. For example, you can't say first in, first out, and then leave a juvenile. And judicial officers do that. You will give priority to juveniles. You can't say first in, first out, and then you don't give priority to some people that are brought up really pertinent issues. Sick people, elderly people, people who are 90 years, 80 years, and somebody's saying, you know, I want my case to be heard. So we have those exceptions, but generally that is a general rule. So that we do not have an issue. Somebody said, I've walked to court for 5, 6 years. What is happening when we are busy handling new cases? That is what I want to say. Then there was a question about, he didn't talk about it, of statistics, evidence-based. I would want to say that, yeah, the statistics are there. We rely on statistics to say that there's improvement. I think that is why prisons have said that now they have seen at the rate at which judiciary is growing, they need to also do regional prisons. So there's statistics that show that the services are being brought closer to the people, and also filing of cases is increasing. The disposal is also happening. But in the criminal justice system, I can assure we are still lagging behind, because I told you it's a chain. So when one actor in the chain is not there, and now the biggest problem we are having is an actor called DPP not being available, and that is affecting the rate of disposal. Maybe at a certain stage, when we get to that level where every judge, every judicial officer has a state attorney, we will come back into this room to discuss and say, how has this now improved and changed? Thank you for listening to me.
Thank you very much, Your Worship, and the other members on the panel. Ladies and gentlemen, I think we have come to the end of the question and answer session. However, before we send the panelists back to their seats, I think it is the right moment for us to have a group photo, such that as they sit at once. We'll begin with the ULS Council. Let us first take theirs as they are, then other members join. Let us have the counsel. Yes, the council. As the development partners prepare the representatives, the development partners will prepare for the photo moment. Do we have the development partners representatives? Let us have the members, those who so wish to take part in the photo moment. The staff at Uganda Law Society also prepare. The staff at ULS, please come forward. Let us have the staff, ULS. Other stakeholders who so wish to take part in the photo, please come forward. Other stakeholders available who so wish to take part, please come forward. As we are coming to the end of the session, we'd like to inform you that we have our guest of honor in the house. Allow me invite the Eastern representative, who will invite the Vice President to invite our guest of honor.
Yes, we are on the final legs of this event. Some attention, please. Mr. VP, I will not take much time. Mine is just to invite you to come and invite our guest of honor. Please.
Thank you, Eddie. A big hand clap to our panelists who just left. It's been a long day. We've held you people here longer than we expected. And I also won't take time. I'll now take this singular honor to welcome our guest of honor. That is Miss Barbara Kilei. She's the country director at IDLO. She's been here with us the whole day. She has had to cancel some of our programs. And the most important thing is that it's because of her that we are actually having this event today. It's because of her that we had the Pro Bono Week made possible. So let's put our hands together for Barbara Kilei. You're welcome.
Thank you, VP. All protocol observed. Good afternoon. I know there's lunch, and I'm standing between you and lunch, but surely have a little bit more energy. Good afternoon. Thank you. My apologies. I think we've kept you here longer than we intended. And VP, it is not me, it is the institution that believes in the need to deliver justice to the people, and we work hard to ensure that that is done. I'm not here alone. I'm here with one of my colleagues, Joyce. If you could just say hello. Joyce is one of our new partner members of IDLO, who's been with us for a while now. It is with deep pride and gratitude that we are here today, I think, for all of us. And as we mark the conclusion of a remarkable week, one that has brought legal services to the doorsteps of communities across Uganda, and from Jinja, Mbarara, Fort Portal to Lira, we have witnessed the power of the law, not just as a system, but as a lifeline. And this lifeline was delivered to more people than we would have planned if we just sat in our offices. This initiative of taking people back to their communities, and I understand and appreciate the comment that has been made that perhaps we need to move away from pro bono and consider a public defense system that actually works, a public defender's office. And there's scope to that. But I think before we get there, there are things that we need to do. There are spaces that we need to be in. There are voices that need to be protected. There is dignity that needs to be provided and protected for the most vulnerable and the indigent in our community. So this particular initiative that has been supported not just by the International Development Law Organization, but also by the Governance and Security Program, the Administration of Justice Program, the different partners who work with us, and the Uganda Law Society members, has been more than a campaign. It has been a movement of conscience, a reaffirmation of our shared belief that justice must not be a privilege for the few, but a right for all. And that is important. Because if we consider the words of Justice Dumbushena, where the rule of law must be upheld not only in words, but in deeds. I'll repeat that again. The rule of law must not only be upheld by words, but in deeds as well. It is not enough to assume that justice exists because the courts are open. We must ensure that justice is delivered beyond the courtroom. And this means that we take it upon ourselves to deliver justice as and when we find justice seekers. So justice is not found in buildings only, or in books, for that matter. It is found in the actions of those who are called to serve, such as yourselves, such as the members of the Law Society, the judicial officers, the prison officials, and all other actors within the justice sector. And given the comments that have just come from the panel that just preceded my comments, it is important for us to start thinking outside the box. Perhaps we have focused mainly on what has to go to the judiciary. It is evident that justice needs exist even outside of the courtroom. And the Hill reports keep reaffirming this. Only 10% of the disputes in Uganda end up in court. That means 90% of the dispute, whether criminal or civil in nature, are outside of the courtroom. What are we doing about those legal needs? How are we supporting them? The comment made from the prison service, from the prison's representative, is that the number of remandees who have been charged with petty offenses, who have been in prison for a longer period than the sentence they would have ordinarily served. My call to the judiciary, can we not do something immediately just to look at the petty offenders who are presently in prison and organize a quick session at the prison services themselves just to deliver services to those individuals? Is it not possible for the office of the DPP to secure public prosecutors who would be present in those sessions to provide justice services for those petty offenses? Is it not something that the Uganda Law Society members can also ensure to participate in and provide free legal aid services to all those charged with petty offenses? You say you are a constituent of 6,000 members. The numbers of the petty offenders, although they were not shared, I am sure that if we were to plan prison by prison, we could be able to do this. The court is in vacation. I leave that to you as a call for you. The calls on the questionable practices by the different justice actors. Is it time that the Uganda Law Society considers its role in promoting access to justice by acting as an ombudsman of the justice sector? You have this mandate. What are you waiting for to deliver on it? It is important for us to interrogate the different systems that are working. I like that the judiciary said that they have seen that the daily hearing system is working, and therefore there is need to explore how to expand that further. I believe with the different actors who are present on this table or present in this room today and online, it is a possibility for us to come together to support the judiciary in delivering on this and interrogating the system of sessions, which clearly leaves us asking the question of when will we get justice. The concern raised on decriminalizing poverty. I know we all laugh at it and we think, well, it shall never be me. But it is us. I don't know how many of us reflect on the comments that are made that I saw my neighbor's house, I saw my neighbor being battered. I didn't do anything because it did not affect me. I saw my other neighbor also being battered. I did nothing because it did not affect me. But now it has affected me. Who will come to save me because I have kept quiet all along? Let the Uganda Law Society not stay silent when there is justice need. There is a justice need that is prevailing. Let the Uganda Law Society be at the forefront of driving legal reforms that decriminalize poverty. It is sad that we are still in an era where trying to make 1,000 shillings is enough reason for me to be arrested and imprisoned. It is very sad. And if that does not touch your conscience, I do not know what will. Because surely we should all be crying out for the injustice that our systems are currently elaborating. It is time for the Uganda Law Society to jointly with the Uganda Law Reform Commission work towards decriminalizing poverty. It is important. The time is now. It is not tomorrow. It is not when you have a new radical, new bar. No. That is the radicalness that we expect from the Uganda Law Society. The numbers have been shared. They're not new. We have all heard about them. We were not gasping with amazement at how we are failing as the justice sector in ensuring that the numbers are dealt with, but clearly it is important, given the fact that in the past week alone, the legal initiatives that have been taken have reached, I think you said 3,000 people. Sheila, where are you? Did you say you managed to reach 3,000 people? Then that shows that it is actually doable. So why are we not reflecting on the successes that have become possible and elaboratively looking down and working with the justice sector and amplifying what has succeeded? I like the fact that I think it was someone from FIDA who asked, what is the outcome document? VP, what is the outcome of this particular session? Are we going to see you as the radical new bar and the council working together with law reform to first and foremost present reform proposals to decriminalize poverty, to ensure that your members, only 5% of your members participated in the Pro Bono Week. It is a mandate, 40 hours was mentioned. Yet only 5% of your members participated. Where is the issue? What will you do to call upon the others, the 677 other council members, lawyers, advocates rather, who did not participate in this? Why is there a lack of motivation to be part of this Pro Bono Service Week? Is it because they're looking to you to integrate pro bono in their daily routine services? And I laud the work that is being done by ASF and others in reducing the pretrial detainees, but it needs to go beyond the detainees. It needs to go to the community itself. It means that we must collectively work together to integrate pro bono legal services in our daily work. Can we, as collectively as we sit here, can we say we all commit to 16 hours a week to provide legal aid, 16 hours a month? It's only 4 hours a week, 1 hour a day, and 1 rest day in that week. Is that too much to ask for the Law Society? Just 16 hours a week, 1 hour of your time every day with 1 rest day for the week. Is that too much to ask of you? Would we not have a better impact by ensuring that everyone has access to justice? Not just sitting in your offices, but going wherever you meet the people and providing legal literacy information. It could be as simple as saying, do you know what would happen to you if you were caught? The other day, what was trending? The people who lock out their husbands, right? Right? Is there a legal repercussion to it? Maybe not. But then the responses showed we have a community that does not understand the law, because there are those who say they would discipline properly their spouses. Where was the Law Society in that conversation? To tell people that some discipline efforts that you may end up taking would land you into prison. Where was the Law Society? Kindly, I call on you to please ensure that legal or pro bono services are ingrained in the services that you provide every other day. Pro bono work is not only noble, it is strategic, very strategic. Stories like those that were told of Michael by AD, I think it was Michael Olopot, who stayed over 11 years in remand prison. What does that tell us? As a Law Society, first of all, did we do all that was needed to make sure that those 11 years are never reached by anyone in remand? You have a legal aid project, you have pro bono hours, you have legal aid service providers. What is happening? Clearly, there is a question on interagency coordination. And at the risk of losing you because of hunger, I will just dash to the call to action. From the Pro Bono Week, it has been very clear that many Ugandans are unaware of their legal rights or even how to navigate the justice systems. It is therefore very important for us to all work together and expand on legal literacy campaigns. Do not just stop at Bukede. do not just stop at NBS, be all over. And I think UBS even has national airtime that can be given for national agendas. Legal services are one of them. Consult with them. For law not to be seen not just as a tool of oppression, but as an instrument of liberation, we must resist and demystify any assumption to the contrary by first and foremost integrating pro bono legal aid as a daily practice for each and every counsel or lawyer who is admitted as an advocate to practice before the Ugandan courts of judicature. To integrate legal aid services into the very fabric of our very own legal practice. Perhaps that is a sustainability measure. I hear Dr. Sylvia talking about how Parliament questioned the ability of government to fund legal aid, and the question of how we will be able to fund a public defenders system. But before then, you as the Uganda Law Society, you as the advocates qualified to practice in the courts of judicature in Uganda, are you integrating pro bono services into your daily practice? You should, if you ask me. It is important, of course, other than that, to find innovative ways, in your terms, radical, right, to align or ignite the desires of other members to provide legal services, including those who are in the law school. Let it be a culture that is culcated from the law school itself. So not just participating in the law clinic, but actually having a course that is evaluated from pro bono services provided during your 4 years as a law student. Perhaps that would be one of the ways to ensure that it becomes our culture. So we must also support the Law Reform Council to expedite the review of the Penal Code and all other acts that decriminalize petty offenses, especially those like loitering, jaywalking, and ensure that when we are doing that, we're also promoting non-custodial sentences. Because it is clear that if prisons only has capacity for 20,000 and they're trying to play catch-up, we need to play catch-up for those who are not yet in prison and make sure they're not going there, either by reforming the laws and changing our own culture. I'm told by my colleagues in the Busoga region how defilement is one of the prevalent offenses. And why is it a prevalent offense? Because of poverty. So finding ways, giving information on legal literacy, financial independence, how to build that, to ensure that this future that we dream of, the future of people-centered justice, is not just a dream, but we are building it case by case, client by client, region by region, from each of you who has chosen to serve. So to the Uganda Law Society, thank you very much for leading this initiative, to prisons and all the other justice actors, the judiciary, the legal aid service providers, the police. We are grateful for your support in this particular effort, and we hope we can continue this journey together, case by case, client by client, region by region, to serve the people of Uganda to have responsive justice services. Asanteni sana.
Wow. There's just one last item before we can break off for lunch. I want to extend thanks to each and every one of us. I'm hoping that the call to action indeed inspires each one of us to rise to action. When we began the campaign for the national bar engagement, we were calling out all our members. And we shall keep that call running and inviting everyone to the front line. Let me invite our Vice President to deliver our final vote of thanks and wrap up this event. Mr. Simwe.
All right. Thank you, Eddie. And just like our previous speaker, the chief guest, said, we don't want to keep standing between here and lunch. But I honestly have no words to express our gratitude and the excitement and the empowerment we've received. Listening to you, Barbara, in itself has been mind-blowing and mind-opening. And from where I was seated, I don't want to ask whoever listened. I'm sure if I sampled, everyone has picked something. Ladies and gentlemen, as we come to the end of this important and high-level stakeholder engagement, I want to sincerely thank each one of you for being part of this conversation. Those who have been here physically, those who have joined us online. From the deliberations of this engagement, you will agree with me that we all now know the challenges in our justice system. Just like it has been stated previously, these issues, most of them are not new, but they demand new energy and new solutions from all of us. And let me report that that is why we have the radical new bar. That's why we have a radical approach, because there's need for a new sense, a new energy, because these issues have been there, but what different way have we tackled them, and what are we supposed to do? Once again, I would like to thank all our partners, especially the IDLO and the Embassy of the Kingdom of Netherlands and all other partners for the support to our different legal aid interventions. To our stakeholders in the justice sector, the judiciary, Uganda Police, which is not here, prison services, the Office of the DPP, Human Rights Commission, Civil for this week. Many of you gave up your time, your energy, and your skills to help people for free throughout the week. That kind of sacrifice is what gives real meaning to the law, to access to justice, to the rule of law. And as we move forward, let us not lose the momentum we have built this week. The questions have been put to us. Questions have been put to me particularly, specifically, what do you intend to do after this? And the question I also have for our members, and the play I make, is that let's not lose this momentum. Let's continue. Our interim secretary likes calling it increasing velocity, that we must increase velocity. There's no going back. Let's keep helping people in our communities who are struggling with legal problems. Let us keep using our knowledge, skill, and our voices to make justice more real for Ugandan, especially the indigent, marginalized, and vulnerable persons in our community. It is the best we can offer. It is the best we can give back to society as professionals in that field. On behalf of our Radical New Bar Governing Council, I affirm, and probably for your comfort, Barbara, and based on the questions you asked, I do affirm that we remain fully committed to serving up to our mandate, and that is to protect and assist the public in all matters connected to the law and support advocates to serve with excellence and integrity. You may be aware that out of our approach, the radical approach, we have the 4 Ds. And these 4 Ds literally cover everything you've talked about here. We have decolonization, and this covers some of the laws we're talking about. Most of them are old laws that can no longer serve the purpose. That's why we have criminalizing petty offenses and poverty, criminalization of poverty. Fighting for that and making sure we have those reforms fall under the first D, which is decolonization. Decolonization is really about the laws, the old archaic laws, beginning with even our own act, the Uganda Law Society Act of 1956, before we got independence. Some of the provisions there are not tenable. They are not fit for the current needs. We also have democratization. We've talked about it. We have demilitarization. We've been talking about trials of civilians in military courts and the involvement of these in our justice system. And also digital transformation. When the registrar was talking, she kept talking about the challenges we are having, and we are wholly embracing digital transformation. And probably for your comfort, your worship, you may be sure that we have also radically transformed. We are moving. Just to let you know, even our usual annual conference for this year, we are calling it the first ever digital transformation, the digital technology festival, because we want members to appreciate, want members to, getting to learn how to use media. She was talking about when they're on call, they're failing to use. You're seeing videos, you're seeing other, people are not muted. And we're being intentional about this because we know that's why that's why we're headed. And probably it's going to have a big solution to the problem, the justice needs we have, and quicker provision of these solutions. So as I conclude, I also take note that we shall establish a clear, reliable mechanism to ensure proper follow-up on all the recommendations given here. We've heard you, we've listened. That's why we wanted this engagement. So we'll have a very clear mechanism to ensure proper follow-up, and also follow up on the cases identified during the week. This problem to make sure that each person who came to us in need receives the full and effective legal support they deserve. This is part of our Radical New Bar Vision 2060, a society where justice is a reality, where it is not a privilege of a few, where access to justice is real and the rule of law is respected. We do continue to call for more support and partnership to build a justice system that truly leaves no one behind. And with that, allow me to, again as I conclude, let you know that our legal clinics across the country remain open to receive and support these clients on a daily basis. I thank you all for your attention and active participation, and I wish all of you journey mercies as you travel back. May the good Lord bless you, and thank you. Allow me invite the CEO to give us the information we need. I know we are standing between you and your lunch. You've been here for a lot of time. We lost 2 hours in the morning before we could begin. But Madam CEO, you're welcome to give us guidance on where do we go from here. Thank you.
Thank you very much. I now welcome all of you for lunch. We shall start with the table of the panelists and council. Please, I'll lead you where lunch is. Thank you.